All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning, everybody, and welcome to this virtual argument before the District of Columbia Court of Appeals. These arguments, as you know, are being live streamed on YouTube, and you can find the link to the arguments on the court's website. The court staff has worked really hard to prepare the judges and the participants to conduct this argument, but of course, technological problems may arise, and if they do, we just ask for your patience. Thank you. We have 3 cases on this morning's regular calendar, and the first one is Tyrone Hunter versus United States, number 18 CF 707. Ms. Bennett, whenever you're ready.
Morning, Your Honors. Elspeth Bennett on behalf of the appellant Tyrone Hunter. I'd like to reserve 3 minutes for rebuttal. May it please the court. Your Honors, we're here today because the government was unable to present sufficient evidence at trial that would have allowed any rational trier of fact to conclude beyond a reasonable doubt that Mr. Hunter actually committed the robberies for which he's been convicted. For clarity, this appeal concerns counts 1 through 23, which are Mr. Hunter's robbery-related convictions. The other counts are not at issue on appeal. These convictions generally fall into 4 buckets. 1 is a conspiracy to commit robbery conviction. There are 11 substantive robbery or attempted robbery convictions. There are 9 related possession of a firearm during a crime of violence convictions. And there are 2 felon in possession charges, 1 for each day of the robberies. Your Honors, if the court finds that there's insufficient evidence to sustain Mr. Hunter's substantive robbery convictions, there's necessarily insufficient evidence on the other counts as well.
Counsel, can we jump right into what I think is a problem that you need to address, which is sort of what I would call the coincidence of the fact that your client, Mr. Hunter, was found and arrested the day he was arrested, found in the car that there is probably sufficient evidence to indicate was involved in this string of robberies. And then you have a bunch of IDs, that in and of themselves may be flawed, may be very flawed, but the fact that several complaining witnesses or victims of these robberies focus on your client, it just seems the coincidence is very, why is it not too much that those, the combination of the IDs and the fact that he happens to be found in the car? What are the odds of that?
I think there's several responses to Your Honor's questions, which are all great questions. We do not concede that there is sufficient evidence that the same car was used in all the robberies, but I will move beyond that, understanding Your Honor's questions. The government has conceded that there's insufficient evidence on the Arenal robbery, and the car evidence is equally applicable to all of the robberies. And so clearly the government has already conceded that the fact that my client was found in the car after the robberies, 3 weeks after the robberies, and there is no evidence tying him to being in possession or even near the car more than 2 weeks after the robberies. The government extracted his cell phone data. There's nothing tying him to the car before January 28th. And so the government has conceded that that circumstantial evidence itself is not enough, period. There's no way he could be convicted just by having been in the car 3 weeks after the robberies. There was no stolen, none of the stolen goods were found in the car for which he's been substantively charged with the robberies. So clearly the car is not enough, which brings us to the next issue. Well, are there other issues in the other robberies, other evidence in the other robberies that somehow distinguish Arenal from the other robberies? And respectfully, they really fall into 2 buckets. One are the robberies where there's no pretrial ID, and that's 5 of them. The second bucket is the robberies where there are pretrial IDs. So I first want to address the ones where there is no pretrial ID. And those are the Fulla, Tahiro, Barlow, Harris Williams, and DeMesa robberies. There's nothing else in those robberies other than a very, very vague description from the victims about the suspect. And those descriptions.
There's a little more. In Fullo, we have somebody who's wearing what appears to be the same jacket with the same hood as we see in the Rodas video where there is an ID, right?
That is correct. Yes. The jacket with the hood is, generally speaking, a consistent description from several of the victims, at least on the January 15th robberies. I think the problem there, Your Honor, is that although there was testimony at trial that Mr. Hunter may at one time have had such a coat, it certainly was not found in his house or in any of his belongings, including the car in which he was found. They did execute a search warrant.
I suppose my point is you can sort of bootstrap the cases like Mr. Fullo where there is no ID with the cases where there is some ID, because if you've got a positive ID from a few people, and then you've got a bunch of other cases where nobody IDs him, but you can see from video evidence that it's the same guy, you can transfer the ID evidence from one to the other, right?
Your Honor, the jury is entitled to, of course, consider all the evidence before them, which does include all of the various IDs. In this case, because the IDs are so weak, and in fact, some victims gave contradictory IDs, and the Rodas ID specifically, which I remind the court is not a charged offense. That occurred in Maryland and is not a substantively charged offense. It's only relevant to the conspiracy charge in terms of an overt act. Your Honor, Ms. Rodas effectively recanted.
It might not be charged, but it's not only relevant to the conspiracy charge. You can use it as identification. Why can't it be used as identification evidence in the other charges?
Your Honor, it's certainly a fact that a jury was entitled to consider, but specifically if we're talking about the Rodas identification, she effectively recanted it on the stand. When asked whether she had identified anyone in a photo array, she said no. And then when shown the photo array by the government, she said, oh, I did.
Her testimony wasn't the only evidence on the point. There was also the testimony of the detective who administered the photo array. So the jury would be entitled to credit what was said immediately after the robbery, or not immediately, but a couple weeks after the robbery, as opposed to more than a year later, where she says, "Well, I really don't remember that much of that." And then her testimony is quite garbled. I'll give you that. But we don't need to rely only on her testimony when we have another account of her more contemporaneous identification.
If you're referring to in the Rodas robbery, if you're referring to the detective's testimony and the photo array sheet, which says she was sure of number 4, he was the shorter one. If that's what you're referring to, Your Honor, I refer you to Exhibit 66, which is the government's Exhibit 66, which is the surveillance video. And it is very clear that the man with the fur-lined hood is not the shorter of the two men in the restaurant.
I've seen that, and I agree with you.
If we're talking about sufficiency of the evidence, it's not.
Can I ask you a question? Focusing on just pick one of the robberies or attempted robberies where there is an out-of-court ID. And if you kind of consider it in isolation, and for any particular one of them, I know that there are various problems. I mean, leave aside the one where the ID was 30%, which I think would be the weakest of them. But take one of the ones where there isn't that kind of a problem. Just considering it in isolation and saying, look, there's an out-of-court ID, the jury can consider it and leave aside all the other corroborating information or coincidental type information from other incidents. Could you point us to cases of ours where we have said, look, it's true there was an out-of-court ID, and then there are some discrepancies about descriptions and the like, and that's just not enough. No reasonable fact finder could find guilt. I mean, just taking one of them in isolation where there is an out-of-court ID, what could can you point us to cases that would lead us to say cases where there is an out-of-court ID like that, and then there are discrepancies that you're relying on are just not sufficient, a jury can't find guilt in that case in isolation?
Yes, Your Honor. I think perhaps the strongest case on that point is the In Re ASH case. And in addition, I again.
In that case, the evidence was the out-of-court person said, well, the out-of-court ID was I'm 70 to 80% sure, and the court says if that's the degree of certainty, that's not enough.
Exactly.
I get that. But what about, that we don't have lack of certainty like that in all of the out of court IDs, do we?
Your Honor, I think we do. The Miller ID is arguably a stronger ID than 30%, except that she told the grand jury, and this came out at trial, she told the grand jury that she's the person she identified in the photo array merely looked like the suspect.
Yeah,
That type
and
of
I guess
looked like language is not sufficient.
Yeah, let me draw a distinction. I mean, one kind of case like in re ANS or ASA is where the best evidence for the government is 70 to 80%. That's one kind of case. And if we say that's not enough because you need a higher degree of certainty, that's one kind of conclusion. If instead the evidence is there's an out of court ID where the witness seemed to have just said that's the person, and then there's impeaching information that one could use to argue, and some fact finders might find that impeachment persuasive and some might not. That seems like a different case about whether the evidence is or is not sufficient. So I circle back around, I guess, to whether you could point us to cases where there is, viewed in the light most favorable to the jury's verdict, an out of court ID that is not qualified. And then there's impeaching information and the court ends up concluding, well, the impeachment information was so strong and the problems, the conflicting descriptions or whatever the other problems were with that incident in isolation were so strong that no reasonable fact finder could find guilt. I'm just wondering if there are cases you're aware of that take that form.
Yeah, I think there are, Your Honor. I would refer the court to Crawley, which I believe is cited in our briefs. I would refer the court to the Beatty case itself, which we cite for the factors regarding reliability of an identification.
Right, and I mean those two cases I'm familiar with, and they are quite extreme scenarios. So I wonder how comparable they are to this. But those are but in any event, the three cases you would point us to would be Beatty, Crawley, and In Re AS or ANS or whatever it is. Those would be your best indicators for us.
Your Honor, I think that's right. I mean, all of the cases cited in our briefs, I do refer you to the full briefs, but those are the ones that come to mind at the time. I think the In Re TLL case, while is slightly different, it's a probable cause situation. I do think that case is illuminating as well. And Your Honors, I also refer you to Judge Beckwith's dissent in Gray versus the United States, which I think addresses these issues quite well.
But it's a dissent. Can I ask you a question about some record issues? I'm not sure that we have everything, all the exhibits, and it seems like you and the government have submitted a lot of the exhibits. There are a lot of them, understandably, but there are a couple in particular that seem important. And I wonder what your view is on them, and also, I'm curious whether either of you has thoughts about how we might be able to get them, although they should have been transmitted by the Superior Court to us somehow. And that is, I think, sorry if I didn't write it down, but I'm thinking it's 154 A and B, maybe the photographs from the cell phone, photographs that according to the government's brief, and the prosecutor made quite a bit of this in closing argument at the trial, but that show Mr. Hunter with a hat with some kind of white logo on it. It seems like, I haven't seen it, so I'm not sure, but it seems like that could be a kind of key piece of evidence. Do you have thoughts on why that doesn't further undermine your sufficiency claim?
It's similar reasons as to the fur coat itself, which is that we're talking about robberies occurring in January and February. We're talking about very common pieces of clothing.
The hat that you can see clearly from the still frames from the Rodas robbery is not so common. It's a pretty distinctive white emblem on the black beanie. And I suspect, although it's curious that we don't have it, that if there's also a picture of your client in that hat from around the same time, maybe leaning on the Audi. I can't quite tell if that's what it's supposed to depict. That's not nothing. I think it's quite a lot. Have you looked at the photo? Does it look like it matches? We'll take your representations at argument, although we would like to see the photo at some point. Does it in fact match what we see in the Rodas robbery?
Your Honor, I have seen the photo, and of course, someone, I'm sure Ms. Kelly, will make them available to the court. I do not. It's the video from the Rodas robbery is blurry at best on the hat. I agree that there appear to be two black hats with little white emblems on them. It's very blurry. It's hard to know, Your Honor. And the white hat concept, which is in the Rodas robbery, again, not a charged robbery. That is not a feature that features in any of the other victim descriptions.
So a lot of them have him wearing a black hat, right?
Some of them are confused whether the assailant was wearing a hat or had short hair. I can't recall any robbery at this time where another white emblem on a hat was notable, which
I mean, you can see why they'd be confused. We have some video and it's quite quick. I mean, the Rodas robbery especially, I'm shocked she said she could identify anybody, how quickly those two ran in and grabbed the bag and got out. I mean, it was within, under 2 seconds.
Well, I think that's precisely why these IDs aren't reliable. I think, again, I've referred, Your Honor, to Exhibit 66. She clearly did not pick out the person who's the shorter of the two in the restaurant.
Yeah, no, I think it's a good point in your favor for why the IDs might not be reliable, but I think it might be a problem if he's wearing the same hat and it's as distinctive as I tend to think.
But Your Honor, that really depends on all of the robberies being linked. That really depends on the jury being able to say, well, because there was a hat used in one robbery and maybe the same car used in these other robberies, then it's all the same person. And the government's already said that the MO theory that these are all the same person is not enough on the Aronow robbery.
I don't think I didn't say anything in your opening, but I don't think they quite said that. It might be that they don't think it's not the Aronow robbery because there's contrary evidence to suggest that it's not him. There's testimony from Mr. Aronow that the guy was much shorter, it didn't match your client at all. So there is affirmatively exculpatory evidence as to Mr. Hunter in that robbery, and that doesn't exist in the others.
Your Honor, I would agree with you, except that the government requested, I'm sorry, I'm getting a lot of feedback. I hope others can hear me. I would agree with you, except that the government requested and received an aider and abetter instruction and a conspirator liability instruction on the Aronow robbery. They did not need to prove that he was the principal robber, and in fact, did not try to prove that at trial.
Can I ask you, I want to make sure I understood something you said at the beginning, because I think Judge Beckwith asked a question about the Audi and what reasonable folks could find about the Audi. And you indicated you were not conceding a point. I want to make sure I understand what you're not conceding or what you're contesting. So do you think a reasonable fact finder could have concluded that the same Audi was involved in all of these charged incidents? Leave aside for a minute what, but just that there was one car that is a connective tissue throughout the whole set of robberies. Is that something a reasonable juror could have concluded here?
I submit no. And I say that because of the Tahiro robbery specifically, where she reported seeing a small black car with 2 doors and made no reference to any special rims, no reference to lights, no reference to a sunroof. So I submit no. And
I do have one other question, I guess, which in your reply brief, I think you cited a severance case of ours for the idea that really the jury and maybe this court also, in assessing the sufficiency of evidence, shouldn't really take all of these incidents and this is not your terminology, mush them into a big inculpatory mass. And I'm wondering, I guess, whether that's right or not right in the circumstances of this case. I think you acknowledged earlier that as this case was tried, the jury was allowed in, let's say, taking the first robbery and trying to figure out, do we think there's sufficient evidence in the first robbery, was allowed to the extent information about other temporally, the rest of the robberies charged in the set of incidents was logically relevant because there were other indications that some of the people or, the car or other features of those cases were similar and logically relevant. The jury is allowed to kind of consider them all. It needs to, at the end of the day, decide, okay, what's the evidence that's logically relevant to this count, which could include a lot of evidence relating to other incidents, and then find guilt about that count. But I just want to make sure I understand what you're saying you think we shouldn't be doing, or that the jury shouldn't be doing when you refer to this idea of an inculpatory mass.
So I'll start by saying that, of course, my firm was not trial counsel for Mr. Hunter. As far as I'm aware, there was no motion to sever the counts made. And I'm not sure that was the right decision, but that is the decision that was made at the time. And the question, I think Your Honor hit on it at the end of your question, which is, while the court the jury rather, may have been able to consider all of this evidence, they still have to find as to each count, and they must consider separately each offense and the evidence which applies to it. And here where we have, frankly, at best, 3 really, really, really weak pretrial identifications, none of those IDs standing alone for each count work, and even combined, they don't pass the level of sufficient.
I have a question about that. It seems like it would be helpful for your position if you could tie together the problem with the identifications, or the arrays, the pretrial identifications. And, it's like there's the famous case, I think, and Sally Clark, who was convicted of, she had 2 babies die, and then was ultimately, they're like, what are the odds that 2 babies could die? But I think she was ultimately exonerated because there was a reason that each of them had sudden infant death syndrome or something like that, which is different from a case like where someone is arguing in a murder case that their 2 ex-wives died accidentally, or not ex-wives, former wives died accidentally, and arguing a third time at a new trial that it was accident. It's hard to, that kind of coincidence seems more reasonable than the kind of coincidence where you can tie the things together. So what is it about it? You don't seem to be arguing that the suggestivity of these arrays, but is there anything, why do you think 4 people focused on, whether it's a good ID or not, a weak ID, but why do you think 4 people focused on your client?
Well, it's an interesting question Your Honor raises, because we have a pending 23-110 motion in the trial court, a motion for a new trial. The government has not yet had a chance to oppose it. Our brief was filed within the last couple months. And we do raise the suggestiveness of the photo arrays as problematic in that motion. That's admittedly not before the court now in this appeal, but we do believe that the photos of Mr. Hunter were not proper in those arrays. In one of the arrays, he is 6 years younger than everyone else. In all of the arrays, he has a lighter background than everyone else. In all of the arrays, his features are more pronounced and more prominent than everyone else. They're much lighter.
Can I just ask for more specific? Do you mean that there's an ineffective assistance of counsel claim for failing to move to suppress the photo arrays?
Yes, Your Honor.
Okay.
And can I ask you, I get the idea that if that was not raised in the trial court, it was rather than trying to raise it in this court under a plain error standard, another approach is to allege ineffective assistance of counsel. So that's perfectly reasonable set of reasons why the suggestivity argument isn't presented to us. But I didn't really pick up in your brief, at least, or at this argument until now, the idea that although you aren't contesting for current purposes its admissibility, when you're trying to figure out the sufficiency of the evidence, that we should be taking into account that if you look at the array, it explains what happened here and undermines the government's evidence. That's an argument that was, I think, fully available to you as a sufficiency point all along. Is that right?
With Your Honor's comment, of course, looking back, wish we had made more of the argument. I think there was a desire to try to keep the arguments in the lane in which they belong, but I think Your Honor's correct.
But it is your position that if we look at the array, leaving aside for a moment its admissibility, which may be litigated in other proceedings, if we assume its admissibility, you think we should look at it, reach our own conclusions about what a reasonable fact finder, how a reasonable fact finder might respond to it and take that into account in assessing what weight a reasonable fact finder could have given those identifications. Is that right?
Yes.
Can I ask you a related question? Because I haven't checked this. In closing, and this may wrap back around to your ineffectiveness points, but in closing, was that kind of a line of the defense argument to the jury? Look, it may seem odd that these people keep picking my client out of this photo array. And I was never a defense attorney, so this would, I'm sure, not be the way a good defense attorney would make any closing argument. But in theory, the point could have been made much, in a much better way by way of advocacy. But it's not, because this array, you look at it and he just leaps out at you. And so it's really not surprising at all. People who didn't know anything about it would pick him out, because that's just the way you would respond. I just was wondering whether that was a line of the defense closing or whether it wasn't. But again, your point may be that's part and parcel of the same ineffectiveness that you're alleging.
I do believe trial counsel made the argument in closing to the jury. I think it was what trial counsel, I believe, should have emphasized more is the unreliability of the identifications. I think it is both combined that really hammer home why these pretrial IDs are unreliable. The certainty that these victims purported to have is so low.
Okay, unless my colleagues have any further questions, we will hear from the government, but we will give you some time, Ms. Bennett, for rebuttal.
Thank you.
Thank you, Your Honors. May it please the court, Catherine Kelly on behalf of the United States. I have a number of points to make, but just before we go off topic, I would like to say that the defense counsel did strongly argue in closing that the photo arrays were suggestive. So that was before the jury at the time of trial, and strenuously cross-examined the detectives and officers who had shown the photo arrays to the various victims during the trial testimony. It's also notable that in the motion for judgment of acquittal that was renewed post-trial, there was briefing on that issue, and on the day of the sentencing, the court denied that in an approximately about 17-page decision, and one of the points that the court made was saying that it did not believe that the photo arrays were suggestive, was saying that there were minor differences, I believe the term they used, in regard to the photos, but that it wasn't in a manner to make the photo arrays suggestive or unreliable. So it disagreed and looked at the evidence.
I mean, are we free to second guess that? Because I have to say, I find it an extremely surprising conclusion. When I look at the photo array, the ones that were used with Ms. Lamont and her daughter is the same one that was used with Ms. Tahero, I believe. I mean, number 8 jumps off the page, and like maybe number 7 is the only other possibility, because the other 7 of them are just sitting there in the shadows, and you can't make out any faces.
Well, Your Honor, I would disagree with that, and I would agree with the trial court's assessment, but I don't think that this is the point anyway. The court was aware of the issue and didn't find that they were suggestive, and additionally, certainly the jury was made aware of that issue as well in closing argument and during cross-examinations, and apparently chose to rely in part on those photo array identifications.
Well, I don't know. I mean, maybe it relied on the fact that they found him in the car and that was it. But I suppose my question is, when conducting a sufficiency review on appeal and determining what a jury might reasonably credit, are we free to look at those photo arrays and say, hey, as defense counsel argued at the MJOA stage, they're not worth a hill of beans because Mr. Hunter's picture is so prominent in that. I mean, it really looks to be like a case study in how not to put a photo array to somebody.
Well, Your Honor, I would say that what you're doing at the sufficiency of the evidence stage is looking at all the evidence in the light most favorable to the government, drawing all reasonable inferences in the government's favor and so forth. So to the extent, and the jury was, of course, judging credibility and making weight determinations that this court should be deferring to. And for those reasons, I don't believe that it is an appropriate thing for the court to say, we find that these photo arrays are suggestive, particularly when that wasn't an argument that was made on appeal in this briefing. And it was a situation where that idea and that argument was in fact presented to the jury. They were allowed to weigh that. They were given those thoughts by defense counsel. So given the standards for sufficiency review, I don't believe it's appropriate for the court to simply say these are suggestive and should be given no weight or less weight. In addition to that, there's just simply, this case has sufficient evidence to support Mr. Hunter's.
Can I just make sure I understand your position about that? Are you saying that it's not open to this court to look at the array and to reach conclusions, which might differ from the trial courts, about what weight to give them in light of such suggestivity as a reasonable juror, in our view, would have to have perceived? So it's like that issue is just not open to us. Or are you saying that's, we can certainly look at that and do those things, but you think that in light of the deference we owe to a jury when we do it, it's not going to change the outcome? I'm just a little unsure about what you think our proper function is there, if any, in looking ourselves at the array and making judgments about how a reasonable juror might have responded to the array.
Well, certainly the court is allowed to look at whether or not there were reasonable inferences, but however, when you look at reasonable inferences, they have to be drawn in the government's favor, and the court must view the evidence in the light most favorable to the government. So I don't believe that it's the court's role, particularly when this is not an argument that was raised on appeal, to address suggestivity anew during the sufficiency review of the evidence. It does not fit the standard for sufficiency review. And turning to the rest of the evidence, there is sufficient evidence that Mr. Hunter, in fact, committed these robbery offenses. As obviously, we can't overlook the fact that there were 4 photo arrays where Mr. Hunter was identified, 4 different incidents over the course of 2 days. But of course, those don't stand alone here.
Can I interrupt here? You say there are 4 arrays where he was identified.
Correct.
Miss Rodas identified him as the short one, which under the government's theory, most certainly was not, right?
He doesn't appear to be the shorter one in the video, as Your Honor said, but what Miss Rodas actually said is she chose number 4 and said that I'm sure he was the one who was the shorter. They both had guns. And at trial, she explained that she was referring to the man in photo 4 when she was saying that these are the ones. So I don't know that it's particularly significant who was shorter and who was taller, particularly since in the array.
Significant because she's saying, I'm sure Mr. Hunter is not the tall guy that the government thinks he is. I'm sure he's the short one. How is that not significant?
Because it's, when you're looking at the photo array, all you have are headshots, and it's not a matter of somebody saying, is this person taller or is this person the shorter one? She wasn't asked those questions. And then in addition to that, she's pointing him out as one of the assailants who was at the restaurant who robbed her of her purse.
Let's say that one of them was across the street, and the government's theory was Mr. Hunter was the one in the store. If she had pointed to Mr. Hunter's photo and said, I'm sure this is the guy who was across the street, you would agree with me that would not be an identification of Mr. Hunter as the person the government posited, right?
It wouldn't be an identification of Mr. Hunter as the person in the store, no.
Yeah, and in the same way, when the only theory is that Mr. Hunter is the tall guy coming in there, and she says, I'm positive this guy is the short guy, far from an identification of Mr. Hunter as the person the government posits, it's quite the opposite. It's certainly not the guy the government thinks he is.
All I can say is that she was not asked about height during the photo array. She chose Mr. Hunter as one of the people who was in the store. And
short one.
For that reason, I don't find that her statements about the shorter versus the taller is significant when you have 2 people who were in the store at the same time standing together committing the robbery.
And she also identified a filler as the other person, right? Somebody who was not a suspect at all.
No, Your Honor, what she was saying, she looked at numbers 4 and 5 and said they were young like these, the people that were in the store. But she was in identifying somebody, she was only referring to number 4, Mr. Hunter. And I would say too, when you look at that, you compare the video, you also have Mr. Hunter in the store wearing the same type of jacket and the light pants that was seen earlier that day in the Barlow robbery video, in the Fuller robbery. There's a black jacket on and jeans, just like Miss Miller said. And again, Miss Miller was the first incident and was the first person who identified Mr. Hunter with no hesitation.
I mean, we can go one by one, but doesn't that description that Miss Miller gave also match the person we see stealing the Audi on the videotape?
No,
Like,
Your Honor, the person
black jacket, about 5'9" to 6 feet, which Mr. Hunter, by the way, isn't, but close enough, I guess.
Mr. Hunter we did not argue that if you see the video from the parking garage and from the building where the person who stole the Audi is walking through the lobby, he just doesn't have the same build, doesn't look like Mr. Hunter. And I don't believe that there's any reason to confuse those two.
Does he have a build that is in contrast to how Miss Miller describes? I mean, the question is not whether or not they have the same build. The question is whether or not Miss Miller's description matches the person who we see stealing the Audi, who the government agrees is not Mr. Hunter.
Miss Miller had described the person as a black male, medium brown complexion, and then had described the coat as a black bubble coat and so forth. I don't recall her mentioning the build, but
yeah, sure. I mean, it sure seems to match what I see on the photograph of the person stealing the Audi. That's my only point with Miss Miller. And was she ever shown that video and asked if that was the guy?
Not during trial, Your Honor. No, and it was never the government's position that it was the same person, obviously.
I know, but maybe the government would have wanted to investigate whether or not she could identify the person who stole the Audi as her robber.
That was not evidence that was presented at trial, Your Honor. And in addition to that, again, you're taking the light most favorable to the government when you view the evidence and when you make inferences. And Ms. Miller chose Mr. Hunter with no hesitation. And then again, you have the connections, not just the photo race, but the connections between these, including the fact that there's ample evidence to show that Mr. Good's Audi was involved in all of these robberies.
Ms. Keller, can I ask you, because you at times today have been saying that there was ample evidence to connect these robberies, but I know that the United States conceded in its brief that there was not sufficient identification evidence to support a conviction in connection with the attempted robbery of Mr. Arno. Can you explain why the United States concedes that and how that concession is consistent? Why you think that concession is consistent with your defending the sufficiency on all the other charged offenses?
Yes, Your Honor. First, I would say that it was the same car in that situation with a partial license plate that matches Mr. Good and a description of the car that fits. But we conceded insufficiency in regard to the identification in the Aronow incident because we believe the evidence was insufficient to identify Mr. Hunter as a participant in an attempted robbery. Because both Mr. Aronow and his father had mentioned that they saw one subject, and because it wasn't clear from what that one person was doing, which is pulling on the door handle of the car, that it was sufficient evidence to say that it was an attempted robbery.
Well, just on the second of those, I mean, that thought occurred to me, but that's not what you said in your brief, at least. Your brief didn't say, we think, consistent with one of the arguments that was being made by Mr. Hunter in his opening brief. You didn't say, well, with respect to the attempted robbery of Mr. Arno, there's just not enough to determine there was intent to rob. It never got that far. That's not what your brief says. Your brief says there, and then maybe it was just unclearly worded, but it did say there was insufficient identification evidence in the Arno incident. So
That's right.
I hadn't understood your brief to rest, though it might have, your concession to rest on the lack or arguable lack of evidence of intent to rob.
Well, there's sort of two layers to that, and I probably should have said more in my brief, but I was frankly so far over the word limit at that point. Our point is there's insufficient evidence to identify Mr. Hunter as a participant in an attempted robbery of Mr. Arenal, both by the actions of the subject pulling on the door handle and by the fact that when you're looking at the evidence in that incident, the two eyewitnesses to it say they saw one subject, which is, it's just not enough to say that he was participating.
And one subject who you concede a reasonable fact finder could not believe was Mr. Hunter. Is that right?
That's correct, yes. The government's theory at trial was that that was Mr. Thomas.
Right.
That was pulling on the door. But, you know, I mean, of course, we're not conceding that Mr. Hunter was not in the Audi then at that point, because certainly the evidence showing he is robbing Miss Harris and Miss Williams shortly thereafter, about a mile away, would indicate strongly that he was there. And also,
well, that makes me wonder again. I think your opponent alluded to this, but that makes me wonder why you didn't think the evidence was sufficient on a Pinkerton co-conspirator liability theory. Aiding and abetting might have been more difficult, but the arguments you're making right now seem to suggest, again, leaving it unless you don't think there was sufficient evidence that there was an intent to rob, and therefore there was really no crime there, no sufficient evidence of crime. But the other points you're making, many of them seem as though a reasonable juror might have resolved them in the government's favor given your overall position on a Pinkerton co-conspirator liability theory.
right, that's possible. But then, of course, if you don't have sufficient evidence to show that there was an attempted robbery going on, then you can't tie him there with Pinkerton liability. So there's that issue as well. So in regard to all of these robberies, Your Honor, you have the consistent goods Audi involved. You have license plate hits in between these robberies, particularly after Mr. Fulla's robbery and after the Rodas robbery, which was, of course, an overt act in the conspiracy and can be used for identification evidence. You have the police approaching Mr. Good in that same Audi on February 8th, and the first thing he does is flees in the car and crashes and then flees on foot. And in the interim, when the car is found, there's 2 cell phones with photos and videos on it linking Mr. Hunter to the Audi. There's fingerprints on the temporary tag.
Before we move on, could you give us your view? First of all, can you help us get our hands on those exhibits involving the photographs from the cell phone? And do you have a different view of what the photograph with Mr. Hunter and the black cat with the white mark on it, how revealing that is?
Yes, Your Honor, I'm happy to get those exhibits to you. The photo that I believe the court is referring to is a photo from January 29th, 2017, and it shows Mr. Hunter sitting on the front of a gunmetal gray Audi with a sunroof, and which is consistent with Mr. Good's Audi, and he's wearing a black knit cap that has it's kind of a small square white logo on the front. That if you see the video from the Rodas robbery, there's a side view of the person we believe is Mr. Hunter wearing that same hat you can see that there's a white logo on it. There's also another photo of him, I believe, on the 5th of February, where he's again with the dark Audi with that same hat on. And so it ties in that regard as well.
So when you say that same hat, you think it's that clear?
It's again, all I can say is that it's a black knit cap that has a small white, apparently square logo on the front of it. I can't say it's clear enough to say what the logo says, but it's definitely very consistent with the hat shown in the Rodas robbery.
Ms. Gallagher, can I ask you a question that's kind of the flip side of a question I asked your opponent, which is, if you take this as a case where there are a bunch of charged incidents and there are, the evidence as to any particular one of them has its weaknesses and its strengths, and then the argument made, I'm sure in closing argument and made in this court as well, okay, they kind of shore each other up, because if you have them, they're all strung out and they have these mutual connections, and when you take them all together, that ends up establishing that each of them, except the R&O incident, was supported by sufficient evidence. If you're going to point us to a case of ours that you think is factually comparable, where you think there were comparable strengths and weaknesses, and maybe cases where there are multiple counts or incidents, and the court was considering the question of whether, given the strengths and weaknesses of each of them, when you add them all up, a reasonable juror could have found guilt as to all of them. Is there a case of ours that you would point to that you think is instructive about how we should approach this and why we should be persuaded by your view of which side of the sufficiency standard this case falls on?
I would point the court to the Bates case as far as the facts go, and that was a case where identification of the assailant in a 2007 robbery using the same car was used as evidence to show that he had committed 2 robberies in 2006. And albeit that that's a situation where the car was owned by appellant's mother at the time, but there were in that situation differences between the style of robberies, and in particular, I recall the 2007 robbery being more violent than the 2006 robberies, and they were all in different parts of the city and so forth. So it's instructive in that regard. This case is not, I'm not saying that it's completely on all fours with it, but that is the closest case that the government was able to find. And what you have here, of course, is stronger in that you have this series of robberies taking place over the course of 2 days, back to back. And you had, among many of them, this similar methodology used, where you have Mr. Hunter hopping out of the front seat of what appears to be the same car every time, and attacking people very quickly, grabbing wallets, purses, and so forth, using a gun, then hopping back in the car. And you also have the time and locations, and then the directions in which the car was traveling. In addition to that, license plate hits in 2 instances. And you have additionally descriptions that are consistent with Mr. Hunter in almost all of the instances. And then you have the 4 photo arrays in which he was identified.
I suppose what I find hard about it, counsel, and tell me why I'm thinking about it wrong, is if that was all you had, I think I tend to agree that it's sufficient, that, you know, this is Mr. Hunter's car, you found him in it, there's descriptions that match him. But what troubles me a little bit is the government would agree that just a few hours before this crime spree started, somebody else had that Audi. The person who stole it, somebody who is prone toward committing, you know, pretty serious crimes. And that person also seems to meet all the descriptions that are given by the witnesses. So what I'm left with is sort of looking at the identification testimony. One person says 30%. I don't think that's worth a lot to you. I think Ms. Rodas identifies Mr. Hunter as the other person than the government posited. You know, CL gives you something, but Ms. Lamont identifies 3 other people that none of whom are Mr. Hunter. It's not great. So I suppose my question is, you know, don't we factor in the fact that we know there was somebody else who had this car? And doesn't that cut pretty strongly against the government's case that he also matches the witness's descriptions?
I don't believe so, Your Honor. No, because again, the build of this person, he just didn't look like Mr. Hunter. The jury again was shown the photos from the garage and photos from the lobby.
I get that he didn't look like Mr. Hunter, but the question is, did he look like the descriptions that the witnesses gave?
My bottom line, Your Honor, is that Mr. Hunter looked like the descriptions that these witnesses gave, and that it was Mr. Hunter's photo that was chosen in all 4 arrays. In addition to that, you have the clothing. You do not have a clothing match, particularly when you're looking at this dark or black jacket with the fur-lined hood, which even Miss Lawson's ex-girlfriend says he owned. That's not the same as what the man is wearing in the lobby of this apartment complex and then in the garage. He doesn't have
not what Miss Miller described. I mean, your best idea is Miss Miller, and she doesn't say anything about a fur-lined hood.
She doesn't mention the hood, but she does say that it's a black puffer coat, which is consistent with Mr. Fulla. It's not inconsistent not to have mentioned the fur.
That's also what we see of the person who steals the Audi, which is a black coat and jeans. I mean, a medium build. I mean, more consistent than Mr. Hunter is my only point.
I don't believe, again, that the person who stole the car is more consistent with these descriptions than what the eyewitnesses to these crimes said. And there were a number of them that mentioned that Mr. Hunter, the person who robbed them, had a slim build. That's not the build of the person that's in the garage. So for those reasons, we believe, again, looking at the evidence in the light most favorable to the government and making all the connections and looking at all the consistencies among these robberies, that the evidence was in fact sufficient. And again, you don't have to negate every hypothesis or inference of innocence when you're looking at the sufficiency of the evidence. And to say that we think that the person in the car initially who stole it is the same person that committed these robberies is looking at it to boost up an inference of innocence that wouldn't be appropriate given all the other evidence in this case. And for those reasons, we believe that there is sufficient evidence in these robberies. The only other point I would make is the Crawley case and the In re ASH case that appellant is citing in their briefs. Those were incidents where they were single eyewitness cases, and that was all there was. There was a photo array that was not a 100% spot on photo array, but that's of course not the situation in these cases. I believe the court in Crawley actually called it something along the lines of a special rule that they use in cases where you just have that one item of evidence as the government's case, which is very dissimilar to this one. So for all those reasons, we respectfully request that you affirm the convictions of the Superior Court. Thank you.
Thank you very much, Ms. Kelly. Ms. Bennett, we will give you a few minutes.
Thank you, Your Honors. I'll try to be brief. I will start with our opposing counsel's distinction of the Crawley cases and others where there was just one single photo ID. Your Honor, the government argued to the jury that the identifications were, quote, the biggest piece of the puzzle in this case. And I think the photo identifications take prominent importance when we're considering the insufficiency of the evidence. And with respect to the government cited case Bates as being the most helpful to the government, the Bates case, we've said this in our briefs, but I will restate it here, is entirely distinguishable. In that case, the license plate down to a T was recognized by all of the victims. In that case, there was exclusive ownership of the car. The defendant himself testified that it was his car and he had possession of it at all times. The defendant's mother said it was the defendant's car and he had possession of it at all times. And the stolen items were found in the car after the 2006 robberies. And with respect to Mr. Hunter's, well, with respect to the build described by the victims and whether it's consistent with the person who stole the Audi or not, it's absolutely consistent. The government has noted that some victims describe Mr. Hunt, the assailant rather, as skinny or slim. Others describe the assailant as medium or regular. Ms. Miller, in fact, did call him, identify him as having a medium build, and that's at February 1st trial transcript at page 190. And then Mr. DeMesa, the last robbery, identified the assailant as having a regular build, and that's at February 8th transcript at page 606. And the identification of a medium or regular build assailant is entirely consistent with the best image in this case, which is in fact the person who stole the Audi. Returning to other points, this court absolutely can and should look at the photo arrays and make an independent determination of whether any reasonable juror could have found them suggestive. What the government's response to this question was not, no, this court is not permitted to. It was merely that this court should not in light of all the evidence, because the court must take the evidence in the light most favorable to the government. That says nothing about whether this court is free to look at the photo arrays itself. And then the only other thing I would like to say, Your Honor, in closing, is that the hat in Exhibit 154B, which is, I understand the court hasn't seen, but we'll see. Take note of the person next to Mr. Hunter in that photo, who is also wearing a hat with a white emblem on it. From a distance, those hats would be nearly indistinguishable, including from a security camera. And I think it's telling that in the wintertime, when someone is wearing a black hat with some sort of white logo on the front, I disagree that it is a square logo. I don't think it can be determined at all what shape the logo is from the surveillance video of the Rodas robbery. But I ask your honors to take that into account. And just coming back to the Aeronav robbery, the government's argument, which if I'm understanding it correctly today, is that actually the concession rests on it not being attempted robbery. And I think counsel might have waffled a little bit between whether it's the attempted robbery or whether it's the fact that there was one assailant in the vehicle. But in fact, the government's not conceding that Mr. Hunter was not in the vehicle given the robbery immediately before and after. I'm having a hard time following the logic of this one. And I really do believe the government's concession, the logical end of it is that the use of the Audi itself is not sufficient to sustain a conviction. I have nothing further.
Okay, if my colleagues have no further questions, we will wrap it up and the case will be submitted. Thank you both, Ms. Kelly and Ms. Bennett, for your briefs and your arguments today, and Ms. Bennett as well for representing Mr. Hunter. I understand your firm is handling this pro bono, so thank you so much for doing that, if I have that right.
Yeah, that's correct. Thank you.
Thank you, Your Honor.
Okay, the second case on this morning's calendar is number 19 CB 560 Vita Surgical Group LLC versus Alberta Ward. Mr. Belcour, whenever you're ready. Sorry.
Thank you, Your Honor. May it please the court. Alfred Belcour for the appellant, Dr. Araya, and his practice. The patient, Latonia Ward, agreed to certain terms for elective cosmetic surgery, specifically liposuction, after consultations. Among the terms was an express agreement to confine all claims to arbitration, both with respect to her claims and should there be any subsequent claim by any of her heirs. Integral to the arbitration clause, part of it, was that any claim must be brought
I think we've lost them.
for reasons that are disputed. The patient this clause with respect to Latonia Ward's own Survival Act claim.
Mr. Belcour, I wonder if you could sort of repeat what you just said, because you were frozen for a moment. I think we missed the kind of heart of the last sentence.
All right, I got a message that the connection was unstable. I hope you are able to hear me. The court below, with respect to the Survival Act claim of the patient, there was no appeal taken from that determination, but the court declined to enforce the arbitration clause as to the wrongful death claim of the heir, and we have appealed that determination.
What do you mean decline to enforce the arbitration clause? Did you move to compel arbitration?
This connection is very weak. May you want to repeat your question, please?
I said, what do you mean by the court declined to enforce the arbitration clause? Did you move to compel arbitration?
We moved to dismiss or move for judgment, which in these circumstances, as this court has held in a series of cases, must be considered as a motion to compel, because compelling arbitration in this case would mean enforcing the 12-month limitation.
Wouldn't that be up to the arbiter to decide whether or not to enforce that? And wouldn't the other side have an opportunity to argue things like fraud in the inducement to get around arbitration and that clause and the statute of limitations that's in the arbitration agreement?
No, Your Honor. These issues are what this court in Plymouth Rock Assurance Corporation and other cases have regarded as gateway issues. For example, in Hercules, a principal case upon which we fraud in the inducement of the arbitration clause was specifically held to be determinable by the court.
I agree with that, Mr. I agree with that as it relates to fraud in the inducement. But how about timeliness of the request for of a claim relative to the time limits in an arbitration agreement?
Your Honor, with respect to timeliness, when it is built into the clause itself, you cannot enforce the arbitration clause without also enforcing the time limit.
Well, I'm not sure I follow that. So I'm not sure I follow that. So let me just make sure I understand. Couldn't your client have responded to the complaint here by saying either hold this litigation in abeyance and refer it to the arbitrator? There's a binding arbitration agreement. And by the way, when we get to the arbitrator, we're going to say that the arbitrator is required to dismiss and deny all relief because this is untimely. Or you could have, so that would have been actually, and issuing, and you could ask the court to issue an order compelling that the matter be raised in front of the arbitrator. So that would be like a classical motion to compel arbitration. Now, I get your point that in some of our cases, we've said the labels don't really so much matter. And if your client had said, dismiss this action because the only place in which it can be litigated is in front of an arbitrator, that would have been another option to your client. What I'm less clear about is whether it's was really an effort to comply with or enforce the agreement to arbitrate, to instead say to the trial judge, you figure out the timeliness issue, not the arbitrator. And that's why I just want to make sure I understand. Do you think there are cases of ours or cases from anywhere that say a party who is the beneficiary of an arbitration agreement can go when sued in court and can say, judge, there is an arbitration agreement and it's got a time limit. If my opponent had wanted to arbitrate, my opponent would have had to do that within 12 months. My opponent didn't do that. And therefore, judge, I want you not to send it to the arbitrator to sort that issue out, but I want you to decide that this is untimely and grant me relief in court. You think we have prior cases that take that form, or are you aware of cases around the country that take that form?
If I may answer it with respect to these cases, first of all, the Supreme, in the case of Howsam, applied the law with respect to arbitration in this way. The parties there had agreed that a dispute would be arbitrated. They did not specify by whose rules or put into the arbitration clause any restrictions with respect to time. The claimant, and this was an employment law case, decided that she would use the National Association of Security Dealers as the arbiter. And that organization rule providing for when arbitration should be commenced. So the Supreme Court said that in that instance, the arbiters would be most familiar with their own rules. So it is for the arbiter to decide that. In this jurisdiction, there are several cases, including a case called TRG I believe, or Hercules itself, where a party is alleged to have waived an arbitration clause for one reason or another. Most of the time, it's by participating directly in litigation. And in this jurisdiction, that decision of whether there is waiver is held appropriate for the judge.
But you weren't arguing that there was a waiver of an arbitration clause. Someone wasn't trying to escape an arbitration clause on waiver grounds. You would have been trying to say, this is untimely. The arbitration tells you where to determine that. You know, an arbitrator is going to be deciding these issues. I don't have to deal with the judge right now, unless there's some objection to the arbitration agreement altogether. You know, we shouldn't be in front of the judge. We should be in arbitration. And so it was a long windup, but let me just see if I can ask again. Are you aware of any case from this court or from any other court that says the issue of whether an arbitration, whether a challenge, a claim that is required to go through arbitration is untimely because the arbitration agreement has a time limit, is an issue for the court to decide rather than for the arbitrator to decide? I'm just asking, it's a very specific question about case law involving sort of the statute of limitations component of an arbitration clause. Are you aware of cases that tell us one way or another whether that is ordinarily for the arbitrator or for a court that is faced with a lawsuit and an issue about whether the matter should be resolved by an arbitrator?
I am aware of no case where a time limit is specifically built into the clause agreed to by the parties. I am aware of cases where, and I will repeat, Your Honor, this is a flip side of waiver. The plaintiff here, the representative of Ms. Ward, was appointed in 2016, early after the death of her decedent.
Well, let me just, I'm sorry to interrupt you with, I just want to make sure before we go off onto some more facts, I want to make sure I understand why you think it's the flip side of waiver. It seems to me that if,
because
no, let me just finish my question. I'm sorry, let me finish my question. Counsel, let me finish my question. So if I understand the way the way it looks to me is your client got an agreement that said, if we're going to fight about this issue, we're going to fight in front of an arbitrator. That's what I want. I want to have the arbitral forum. And your client is then sued. And it seems to me that if your client really wants an arbitral forum, then your client should have said, I don't want to fight these issues, including statute of limitations or any of that in front of a court. I didn't want a court forum. I wanted an arbitral forum. So if this is overall an enforceable arbitral agreement, then I want this litigation to stop. I don't want to have to pay the expenses and bear the burden of full-blown litigation. I want the matter to go to arbitration. And then we'll fight for the more efficient, less costly, more informal procedures in front of an arbitrator about whether this should just be dismissed. The arbitrator, instead of doing all this in court, I'll go to the arbitrator. I'll say, arbitrator, 12 months, we're done. And I don't quite understand why your client didn't do those things, and why, given that your client didn't do them, we should treat what your client did do as a motion to compel arbitration that is interlocutorily appealable. Why should we not say this was not a motion to compel arbitration by its label? It wasn't by its substance. It was really an effort to get the trial court to grant final relief rather than going to arbitration. And I'll give you a hypothetical. I apologize for adding a hypothetical to this, but here's the hypothetical. Imagine there had been a damages cap in the arbitration agreement. So the arbitration agreement said you got to bring it within 12 months, and no damages can be an amount of more than $100,000. Or no, differently. Let's say there had been something that said, and the patient and her heirs will be limited to getting damages only if they can show an intentional tort. If this lawsuit had been filed and the issue had been, there's no evidence, if your client had sought summary judgment on the theory that there is no evidence, no material dispute the fact that there was an intentional tort, do you think you could have, rather than saying, let's sort all that in front of the arbitrator and filing a motion to compel so that the arbitrator would sort that out, you think you could file a motion for summary judgment that would say, look, the arbitral award, the arbitral agreement says only intentional torts. This isn't an intentional tort. Enforce the arbitral agreement in its substance, not in its process, by granting me summary judgment on that theory of whether there's a material dispute fact. You think you could have done that?
No, that the issue in that hypothetical is not a gateway. If I can answer, and I would request some time to answer, Your Honor. If I could answer with respect to the 12-month limitation in a couple of different ways. First, there is the procedural answer alone for this court, for appellate jurisdiction. The trial court applied the 12-month limitation with respect to the Survival Act claim. That was not appealed. So the enforceability of the 12-month limitation in the context of Your Honor's questions is not properly before this court. There was no appeal. There was no cross appeal.
Well, I agree it's not properly before us, although just to be clear, your opponent's view is they wouldn't have had a right to appeal. This case isn't over yet. And so now is not the time to appeal.
Well, that's an
that they haven't
incorrect
contested
position.
it yet doesn't mean that it won't at some point be in front of somebody. It just means I assume that they don't think they had a right of interlocutory appeal with respect to that, because they certainly were trying to compel arbitration.
Judge, with respect, that's an incorrect position because a motion to compel or grant arbitration is immediately appealable. The statute, its legislative history, and the case law of this jurisdiction all point that there is an interest in resolving the enforceability of an arbitration clause as promptly as possible, precisely to avoid doing a useless act, whether the costs of arbitration are cheaper than litigation or not. And as Your Honors may be aware, maybe not aware, the cost of arbitrations in today's world is not insignificant. And so it may be quicker, but it may not necessarily be cheaper. The issue of waiver is a gateway issue. And for someone to be aware, having obtained the medical records and having been appointed as personal representative of a 12-month limitation in an arbitration clause and then not file suit for close to 2 years later is another way of saying that this is a gateway issue.
All right, let me try a spin on Judge McLeese's question. Let's just assume that it is a statute of limitations issue, but there's just a dispute about when something was filed. You know, it's at the deadline. There's a factual dispute about whether or not this waiver was signed on September 15th or 16th, and they filed it right on the day that is either a day late or right just in time. And then you file for summary judgment and say, this is a day late. They say, actually, we think it was just in time. Is that something that would go before the trial court? The trial court would get to decide that, or is that something that should be left to the arbitrator?
If there's a factual dispute where taking of testimony may be necessary, I can see where the policy of arbitration might be applicable.
Oh, I think
there
there might be a factual dispute about unconscionability.
No,
I know there's a legal question, but there's also about the process in which she was given these forms, 25 minutes before the surgery. Like those are all things, sorry, I might have a ring. Those are all things that might be proper for factual development.
First of all, Your Honor, on unconscionability, that was not raised below. Second of all, the facts with respect to unconscionability are undisputed as a matter of record. This decedent was presented, and it's reflected in writing in the record, was presented with the arbitration agreement in June of 2015, more than a year before her liposuction procedure. Weeks before her liposuction procedure in September 2016, she came to the office and had further consultation. And according to the written matters of record and the declaration of record, all her questions were answered. The doctor went over the procedures and the risk attendant to the procedures. Now, there's no specific.
My only point is these seems like things that under the agreement, if you wanted to enforce it, would be left to an arbitrator.
I disagree, Your Honor, with all due respect, because the the numbers of issues that have been held appropriate gateway issues in this jurisdiction suggest that when there is a clear, unambiguous, undisputed 12-month limitation before which an arbitration claim can be made, and there is a clear, unambiguous record that demonstrates that that particular time provision was not met, it would be requiring the party to do a futile act to engage and pay for an arbitrator to do what this court has accepted could be a gateway decision and enforce the arbitration agreement.
But just to clarify, you're saying, when you say this court has accepted the timeliness requirement in a arbitral agreement when you need to get to the arbitrator as a gateway issue, why do you say that? Because I have been trying to see whether there are actually cases that say that, and so far I haven't heard you mention any.
That's right, Your Honor. I'm not saying that this court has accepted, because no such case, to my knowledge, has presented itself. But this court has on multiple occasions held that a waiver is something for the judge to decide.
Got you. Now, let me just make sure.
I can't think of a different way of saying the same thing.
Counsel, I take you to have conceded that at least potentially, if the applicability of the time limit turns on issues of fact, then perhaps it's not a gateway issue and instead needs to be handled by an arbitrator. Is that right?
If there's no dispute as to a material fact and the matter can readily be handled as a gateway issue, it should be handled as a gateway issue.
Yeah, leave aside facts. Let's say that the statute of limitations provision says something like, the arbitral, you have to seek relief from an arbitrator within 12 months unless the matter is a continuing tort. Or from 12 months
is what?
12 months of discovery of the injury.
Right.
And then there's a legal dispute under, the case law of the pertinent jurisdiction about whether when there was discovery, and partly that could be a matter of fact, but also could be a question of the parties are citing different laws about whether different cases about whether something's a continuing tort, whether it isn't, whether, how to analyze discovery. Do you think that's all appropriately a gateway issue for the judge to decide, or do you think it's something that a party who has secured an arbitral agreement has a right, if he chooses to exercise it, to have the arbitrator decide?
If the issues that Your Honor is pointing to in your hypothetical are issues such as when was there knowledge of the claim? Does the discovery rule apply? What is the appropriate statute of limitations in terms of the law, not the clause, but the law? And when does the law say that the bell rang for the bringing of an arbitration claim or a lawsuit? Those are matters that I would consider not to be gateway matters and would be appropriate for referral to an arbitrator. But I repeat, where it is clear and unambiguous and not subject to a genuine dispute, that the clause itself, integral to the clause, provides that it must be brought within 12 months, to say that has to be referred to an arbitrator would do violence to this jurisdiction's policies favoring arbitration.
No, it doesn't have to be referred to an arbitrator. Your client could waive that right. Your client has a right to have an arbitrator decide it, assuming it's an enforceable arbitration agreement. Your client has a right to have an arbitrator decide it. If you decide, you know what, in this instance, it's so clear and so easy that I'd rather not assert my procedural right to have an arbitrator decide it, go ahead and do that. That's fine. But the problem is, if that's your choice, arguably, then you aren't asking for arbitration. And if the trial court disagrees with how easy it is or doesn't grant you relief ultimately, then if you may have to wait to the end of the whole litigation to get an appeal, because you're not trying to enforce your procedural right to be in front of an arbitrator rather than in court. You made a judgment that it would be more efficient to do this in court, and you may be stuck with that option and lose the possibility of interlocutory appeal. That's the issue that's in front of us, at least. Well,
if there's anything that's clear in this case, Your Honor, is that the appellants, Dr. Araya, as promptly as possible and more than once moved to ask the judge to resolve this issue. If that's not what Your Honor would consider to be a waiver, I don't know what would be. He
Well, no, I
wanted-
think the issue is there's a question about whether that's a waiver of your client's right to arbitrate. Because if you're wrong, this is not a gateway issue, as you're calling them, and really it was for the arbitrator to decide, however easy it is. If you wanted that, then arguably by saying, you know what, I could have an arbitrator decide this, but I don't want to. I'm going to try to get a trial judge to do it. It's arguably, if there's a waiver of arbitration here, at least arguably, it is your client in seeking summary judgment on this ground rather than having the matter referred to an arbitrator to decide. And that'll again wrap back around to whether it's this is a gateway issue in the sense that you described. But I don't think it's like a waiver of arbitration.
Your Honor, that circumstance would be no different than the litigants in Hercules, for example, TRG Customer Solutions, who argued for arbitration and argued that there had been a waiver, and the court found that waiver was an appropriate issue for resolution by a judge. By arguing that the clause should be enforced, with respect to matters that this court has already said are appropriate for a judge to resolve, it should not be considered to be a waiver of the arbitration. It is the issue with respect to arbitration. It is to enforce the arbitration clause, including its integral 12-month limitation. The law in this court's decisions has said more than once, the law does not require doing a useless act. If it's there for everyone to see, there's no point in referring it to a private decision maker at a cost to these parties. There's just no good reason to do that. And that's what Your Honor's questions are suggesting. And I wish to urge, with all due respect, that the issues that have been briefed with respect to what was appropriate for plaintiffs to appeal now, and by failing to appeal now, the issue is no longer able for this court to expand plaintiffs' rights under the El Paso decision. The plaintiff cannot leave this court with more rights than the plaintiff entered this court. The plaintiff did not appeal the propriety of the judge's 12-month limitation application. The issue before this court is whether or not that whole arbitration clause is something that became part of the genetic material of the wrongful death claim by virtue of the decedent's express agreement to it, and also by the decedent's express agreement to include her heirs in the clause. We haven't had a jot or a tittle of a discussion about that.
Can I just
which is
understand
only
the
issue before
argument?
this court.
If the disposition here was that you didn't have a right to bring this interlocutory appeal, how has Appellee walked away with more rights than when she came in?
Because if the grounds are that the judge was not correct in applying the 12-month limitation, that would affect the judge's decision with respect to the Survival Act claim.
Maybe not. They always have the right to. They already, regardless of what we do, might have a right to appeal that once the litigation winds down in the trial court.
No, Your Honor, I disagree strenuously. The time for that is over. I refer Your Honors to the National Trade Production case, where specifically there was no timely appeal taken on a Survival Act claim. There was no cross appeal.
But counsel, I don't understand. You are claiming that you have a special right to appeal right now because although ordinarily, this case is not over. Ordinarily, no one would have a right to appeal. You're claiming a special right to appeal because you're saying that there was in effect, a denial of a motion to compel arbitration. We've been discussing whether that's true or not true. That may be right, it may not be right. But whether it is or isn't right, your opponent has no such right. If it's going to have a remedy from what it may believe was an incorrect dismissal of those counts, it would have to wait, I think, until there's a final judgment, and then it could raise those topics.
No, Your Honor, with all due respect, that is simply incorrect. The DC Code 164427A1 provides that orders enforcing and not enforcing are immediately appealable. So with respect to the decision below, to apply the arbitration clause as to the Survival Act claim,
Counsel, you used the
that
word
is
enforce.
appealable as a final order now. And when it is not appealed, it becomes, the appellate right is lost.
I thought what you said the word enforce. Where is that in 1644-27?
It says compel arbitration.
And so your
In
opponent's
this
view
case,
is,
they're tantamount to the same
Right.
thing.
well, your opponent's view is that this was not an order denying or granting a motion to compel, and so they don't think anybody had a right in their
But,
interlocutory.
but my brother is ignoring the precedents, including the Wallace decision, which specifically said you look to the substance of the relief requested.
Right,
not
and,
the
and we've been
label that is
discussing
put on the-
right, and we've been discussing whether the substance of the relief requested fits within the understanding of those terms. But you're saying also that you think the order granting summary judgment was in substance an order granting a motion to compel arbitration to the extent it terminated, granted summary judgment against your opponent on the other counts, and therefore your opponent had a right of interlocutory appeal. And moreover, not only did they have it, but you think it's a mandatory interlocutory appeal, so that if you don't take it, then you lose the ability to raise the issue later on. Is that right?
Yes, that is absolutely right. It is not really an interlocutory appeal. The statute says that it shall appeal as from an order or a judgment in a civil action. It is not really an interlocutory appeal the way a 54B certificate or a 1292B appeal might be. It is as a final order or judgment, and that was not done.
Okay, Mr. Belcour, we've allowed you to go quite a bit over your time. We will give you some time on rebuttal unless my colleagues have further questions.
Thank you, Your Honor.
Mr. Hansel, whenever you're ready.
Thank you, Your Honor, and may it please the court, it's my honor today to represent Alberta Ward in connection with her wrongful death claim and the issues on appeal. The first issue for the court is the question of this court's jurisdiction. Neither in name nor in substance did my colleague file a motion to compel arbitration. There was not a denial or a grant of a motion to compel arbitration. So this court is not granted jurisdiction under DC Code 164427. There were a number of issues that had counsel wished to arbitrate, he should have moved for arbitration. And his argument, I suppose, which I don't believe the law allows, is it would have been futile because of this time period that had gone by. And those are issues for the arbitrator to decide. So for instance, under DC Code 164407D, there's discussion about whether or not those claims are appropriately subject to arbitration, lack merit, or are grounds for the claim that have not been established. Also under the Houseman case, which is a Supreme Court case that my brother at the bar cites, the court there held that questions of arbitrability is a gateway issue that bars the trial court from considering the procedural merits of the claim. And the procedural issues that ought to be submitted to the arbitrator include those that are very much before this court if we pierce through to the merits. They include allegations of waiver, delay, or like defense to arbitrability. And what Houseman said about that at page 84 of the decision was there is a presumption is that the arbitrator should decide allegations of waiver, delay, or like defense to arbitrability. And my colleague suggests, I think underlying his argument, that in some way these issues are predetermined in some sense because of the passage of time. But in point of fact, it required, his motion included a more than 20-page declaration from his client. So these questions are steeped in factual issues.
Excuse me a minute, Mr. Hansel. Mr. Belcour, could you put your your computer on mute. Now he's frozen. Can you hear me, Mr. Belcourt? Okay. I don't know whether he can hear us. Mr. Belcourt, can you put your computer on mute when you're not speaking?
I was calling the court because I'm having trouble with my connection here. I don't know why, but I'm missing most of what is being said. It's freezing. So
Yeah.
I don't know what to do other than call the court.
Okay, maybe Mr. Hansel can continue and summarize the beginning of what you've said for Mr. Belcourt's purposes, although if you go outside the context of something you said in your brief, be sure to make sure he's heard that.
Thank you, Your Honor. I don't think I have, but very briefly, I suggested to the court that this court lacks jurisdiction because under DC code, there was neither a motion to compel arbitration filed or granted in name or in substance. Counsel in this case clearly believed that there were significant factual issues that had to be resolved by the court in connection with his motion because he filed a 20+ page affidavit from his client. That demonstrates the need for an arbitrator to decide those issues if in fact he wanted them decided. I do think it is the case that in submitting those issues to the trial court that he has indeed waived arbitration. I think that's a question for a different day. The threshold issue for this court today is whether or not there was a motion to compel arbitration filed and whether or not that was in fact how it was treated in substance in the filing and in substance by the court. And that is not the case. The filing sought dismissal. It did not seek reference to an arbitral tribunal. The pleadings in this case, the briefing makes it very clear that both sides have significant issues with respect to the application of the underlying terms here, including the time limits, whether the agreement is unconscionable, whether it's unethical, whether or not it's enforceable through all the mechanisms we raised.
Judge McLeese, you're on mute.
I tried to unmute myself but failed. Sorry, Mr. Hansel. I want to pick up on one word you used there. You were listing a bunch of things that are disputed, and among the things you listed was about the presumably 12-month time limit.
Yes.
Is there actually a dispute about assuming arbitrability, that you're required to go to an arbitrator with respect to this claim, which I know you dispute, and I also, in a variety of respects, both with respect to the Wrongful Death Act claim, but also more generally about the enforceability of the arbitration agreement. But assuming that you have to arbitrate that claim or others, and assuming that the arbitral agreement is enforceable, is there actually a specific dispute about how the 12-month period works or whether it was met or not met if it is applicable?
So I have to parse the question very carefully because it folds within it a number of different questions, I think. Let me
try to make it a simpler one because it had a big windup for which I apologize, but I think at bottom it has only one part, which is, did you dispute in front of the trial court, or do you dispute now, anything that is specific to the 12-month time limit, how it functions, whether if you are required to arbitrate, it was met or not met? Are there disputes about that 12-month, specific to the 12-month time limit, rather than broader disputes of various kinds that we have been discussed? That obviously there are.
So my answer, as I understand the question, Your Honor, is yes. And the issues with the 12-month period are the enforceability and conscionableness of that period, of that provision. And so, for instance, factually in this case, our client was provided with a document that said it might be 8 months before she knew whether or not the surgery had worked. 8 months before swelling and pain and other things subsided.
That's a good answer. I take it as a very well thought out answer. So, but let me ask a follow-up question, which is, isn't it true that that dispute about the enforceability of well, is it or is it not true that that's the kind of gateway issue that a court actually would decide? So let me, and another way of trying to avoid that complication is to say, do you think are you raising any issue that an arbitrator would appropriately decide about, again, assuming arbitration is required, that an arbitrator would decide about how the 12-month period works?
So I think that my opponent is, and therefore the question of whether or not it applies is indeed a question of waiver and delay, which under Houseman are specifically for the arbitrator. And so because my opponent has said 12 months has passed and we have therefore waived and delayed, that under Houseman is an issue for the arbitrator. Now, parsing it a step further, our defense or answer to waiver or delay does involve the applicability and enforceability of A, the whole contract, and B, that specific term. If the only issue were that, then counsel's point would have more strength than it does, but it isn't, because the first order issue that counsel has raised is one of waiver or delay, which under Houseman, which is again the case he cites, we both cited, it's a Supreme Court case, is an issue for the arbitrator. So when his issue is we have waived and delay, that's something he must ask the court to submit to arbitration. And if we look at his pleadings, what he said to the trial court, which is what controls his rights and whether they were waived, and his appeal that we're here on, is that this 12-month period was exceeded. And it's not just the 12-month period. There was a 9-month notice period, but by which time my client must have an affidavit from an expert witness, even though the procedural notes she has and the consent she signed suggests that it will be at least 8 months before she knows whether swelling and pain and other things subside. Now, of course, she died, but we look at arbitrability and enforceability from the perspective of the contract as it existed when signed, and there's case law to that effect. So I think the best answer to your honor is we look at, in fact, what claims were asserted by the movement in order to judge the movement's motion and the appellant's right to appeal. And the movement made claims of waiver and delay, and the appellant made claims of waiver and delay. And without those claims, we never get to any of our questions of whether or not the agreement was enforceable. So you must first decide waiver and delay, and the back and forth there is back and forth that's for the arbitrator. And it's self-evident in this case that it involves not just a simple threshold look at the calendar, but a deep analysis of the facts of this case. Again, my brother at the bar.
Yeah, counsel, I'm curious about your answer to the following question. If your opponent had actually filed a motion to compel arbitration and it said, look, I want an arbitrator to decide everything here except whatever, if you had been raising unconscionability in a timely way, maybe that would have been a threshold issue about whether there's an enforceable arbitration agreement at all. And imagine that the trial court had essentially ruled as it did by saying, I think there is an arbitration problem as to a bunch of the counts, but with respect to the Wrongful Death Act count, my conclusion is that there isn't an arbitral agreement that binds your client because of the substantive issue that we haven't focused on much. Do you agree that that order would have been an order, if that had been the request, would have been interlocutorily appealable as an order refusing to compel arbitration of the Wrongful Death Act claim?
I think aspects of it would, Your Honor. So in some aspects, that sounds to me like an appealable order, but it's very hard, and I'm trying to be fair to your hypothetical, but it's very hard for me to answer because there were claims in different buckets. But
okay, so to simplify, imagine a hypothetical case where the only claim being raised was a Wrongful Death Act claim by an heir, and there was an arbitration agreement, and the trial court, and there was a request to arbitrate, and the trial court said, I'm not going to make that the heir arbitrate because the heir isn't a signatory, and I don't think that's how I understand the applicable provisions of law. Do you agree that a trial court ruling on that issue saying, no, that's not arbitrable, there's no requirement for this litigant to arbitrate that claim, that would be interlocutorily appealable?
I don't think so, because I think that is.
Well,
one of the
actually,
issues.
it wouldn't need to be interlocutorily appealable, I guess, perhaps. Well, actually, it might be. But why do you say, so I interrupted you and I'm going to de-interrupt you belatedly, sorry. Why do you think that would not be interlocutorily appealable?
So there's a question of who would be appealing and what their argument would be, but set that aside, of course. I think that is one of the issues that may be entrusted to the trial court. There's a distinction in my mind between ordering or not ordering arbitration and the grounds on which it's done. Here, it's a question of delay and.
Well, again, I really want to make sure I understand your answer to this hypothetical, because I thought I was intending to make this easy, and I seem to have made it hard. So either I'm missing something or I'm not articulating it well. So let me try again. A single count, wrongful death action. The defendant says, I shouldn't have to be in court. I want to arbitrate this claim because there is an arbitration agreement that was signed by the patient who is now the decedent. Trial court says, no, I don't think that's enforceable against the heir, that arbitration agreement, so I'm not compelling arbitration. The defendant says, well, I wanted arbitration, I didn't get it. The trial court has denied my request. I am going to file an interlocutory appeal under the statute that's at issue here to get the Court of Appeals to tell the trial court, actually, this case should be in arbitration. I thought it was pretty clear that that would be interlocutorily appealable, but you're telling me you think maybe not?
So I think yes, with the footnote that I would want to carefully examine the grounds of the court's opinion against the.
I think the grounds are exactly like the grounds in this case.
Yeah. Okay, then I think in general, yes.
Okay, and then my question then is, I was taking that as the first step, which I thought was easy, and I apologize for making it complicated, to a follow-up question, which is, leaving aside what your opponent asked for, that's what the order ends up saying. The logical import of this order is, I would never send this claim to arbitration, this wrongful death act claim to arbitration. Does it matter, and we have said in our cases, we don't really care so much about labels and the like, does it matter for interlocutory appeal that the substance, the logical import of the court's order is, this is not an arbitrable claim, I would never send it off to arbitration? Does that matter, or do you think that that's not enough?
I think what matters is the request that was made. And the reason it matters is the waiver issue Your Honor raised. By making that request and suggesting that this issue ought to be decided by the Superior Court and urging the trial court to decide it, which the trial court did. Keep in mind, as to other counts, the trial court absolutely decided all of the merits of these issues that the case law very clearly leaves to the arbitrator. And the arbitration agreement here, if the court reads it, is a may agreement. It says the parties may. Now, in the consent, which is a different document, it's transmogrified into a shall. There's a consent that she signs later that says everything shall be submitted, but the prior document is may, so there's some conflict there. But in any event, there is a clear waiver when the proponent of arbitration goes to the court and submits clearly arbitrable issues to the court. It is waiving the right to go to arbitration. So in my view, under those circumstances, there's no path from where we stand today to arbitration, nor was there any path from once counsel filed that request, because the issue is not so much what the court rules when we're asking the question of waiver of rights of Dr. Araya, but instead is, what did Dr. Araya request of the court? Because it is that request that waives his rights, or that submission of those issues to the court.
Well, counsel, I mean, the statutory language at issue isn't focused on the request. It is focused on the effect of the order. It says an appeal may be taken, this is 4427A1, from an order denying or granting a motion to compel. Now, the motion part starts wrapping in the request, but the focus is at least equally on what the effect of the order, or at least also, maybe not equally, I don't mean to prejudge that, but it's at least also on the character of the order.
Well, Your Honor, so my respectful suggestion is it's an order denying or granting a motion to compel arbitration. So it must be a motion to compel arbitration. not one for summary judgment that seeks outright dismissal. And if
Well,
if-
again, I mean, I take your point as an original matter of statutory interpretation, but your opponent, I think correctly to this extent, argues that we haven't been so rigid about the label of the motion. And so we have a bunch of cases that treat as interlocutorily appealable motions that are captioned motions to dismiss, if we think that, they are properly understood, whatever that can wrap in, as in effect motions to compel. So the label, we haven't been very rigid about the labeling of the motion.
But the problem with that view in this case, Your Honor, is that it would create the following circumstance henceforth, and certainly in this case. The proponent of arbitration could see that they have an arbitration agreement, know that the case law requires certain issues to be arbitrated and submitted to the arbitrator, and then get 2 bites, not 1 bite at the apple, because they could first come to the Superior Court and submit those issues. And if that's not a waiver of the right to arbitrate, then they get 1 bite at the apple there. And Mr. Belcure did that, and Dr. Araya rather did that, and benefited from it, because the Superior Court dismissed 5 of the 6 claims. We're only here on the 6th. And then under the world in which Your Honor just posited, on that one last claim, they get the 2nd bite at the apple in arbitration. And I suggest to the court, there's no case law or statute that suggests that they ought to get 2 bites at the apple. Instead, they own their ability to either go to arbitration or to go to Superior Court. And if, under their theory, if this is an enforceable agreement, applies, and on the merits it doesn't, and we incorporate our papers. But if it applies, they own that ability to choose, and they made a choice. And if we don't have them live with that choice, then in reality, going forward, and particularly in this case highlights the problem, because they won 5 of 6. They would get
how do you distinguish Hercules?
I'm sorry, Your Honor.
What do you say about Hercules, which was a motion to dismiss a complaint that was because it required arbitration that was denied?
Yeah. So in Hercules, there's 1 bite at the apple because all those issues are preserved for the arbitrator, and it's not a waiver because all the arbitrable issues that ordinarily are for the arbitrator are not submitted voluntarily to the court. That here, the whole bundle of arbitrable issues in an incredibly lengthy pleading with a 20+ page affidavit, he pushed all his chips, Dr. Araya did, into the middle of the table and reserved nothing for arbitration. So to allow the court to dismiss 5 of 6 claims and then send the arbitrability and the other bundle of arbitrable questions to the arbitrator as to the 6th, it gives an unfair double bite at the apple, and in fact defeats the purpose of arbitration, which is to make things faster and simpler and smoother. And that's utterly defeated by the concept that we can first go to court at the choice of Dr. Araya, at the choice of the proponent of arbitration, submit all those issues in court, and then go to arbitration. All of the case law about arbitration talks about streamlining. The reason that counsel argues we have an interlocutory appeal is, after all, because these issues all ought to be decided by the arbitrator. The Superior Court ought not be making these proclamations, and we get to come.
I'm sorry. And what are the issues he put to the trial court that didn't regard the enforceability of the arbitration agreement?
Your Honor, that I think, in fairness to my memory, I think that would be an almost impossible question to answer in completeness.
Give me one.
Okay, so for instance, under Houseman, issues of waiver and delay are for the arbitrator, and he submitted those very clearly to the court. His chief
waiver and delay as to the enforceability of the arbitration agreement?
As to the time period, the 12-month note and the 9-month notice period and the 12 months, and those under Houseman, under Supreme Court precedent, are questions for the arbitrator, particularly when the answer to them.
I understand the position. I really do, but isn't everything that they put before the trial court, doesn't it all go to, it was not on the merits, it was about the enforceability of the arbitration agreement, right?
Respectfully, I don't believe so, because there's a 20-page affidavit from Dr. Araya that goes deep into the merits, all about, what he did, what he didn't do, talks about him administering the lidocaine. Those are merits issues.
Did they ask for summary judgment on any merits issue?
I think they asked for summary judgment on issues that were both for the trial judge and for the arbitrator, certainly. And it required the decision, it required resolving what otherwise would have been factual disputes if it was the appropriate form to present them. But of course it wasn't, because arbitration is. But if the court gets past this issue, of course, there is the point that Ms. Ward as a person is not bound by this arbitration agreement, and that it does not apply to her wrongful death claim. And I'm happy to address the merits. I know my time is up. So if the court would like to hear from me on those points, I'm happy to discuss them.
I defer to my colleagues on that.
Thank you.
Thank you. Thank you. Mr. Belcour, we will hear from you again.
Yes, thank you, Your Honor. In view of the colloquy, I should like to point out these cases that will be particularly useful to answer Judge McLeese's inquiries with regard to this court's precedents treating motions that are not called motions to compel as immediate. Of course, there's the Hercules case, which the court is well aware of. National Trade Productions, 728 Atlantic 2nd, 106. Robinson versus Booker, 561 Atlantic 2nd, 483. 561 Atlantic 2nd, 483. Evans versus Dreyfus Brothers, 971 Atlantic 2nd, 179. 971 Atlantic 2nd, 179. Your Honor's question with respect to the immediate appealability, where the issue is that it's being applied to a non-signatory, was the precise issue in Giron, Giron, versus Dodds, held to be immediately appealable. 35 Atlantic 3rd, 433. 35 Atlantic 3rd, 433. Issues with respect to the statute of limitations waiver and the like were held to be immediately appealable in the Plymouth Rock Assurance Corporation case, 987 Atlantic 2nd, 458. 987 Atlantic 2nd, 458. The Howsam decision that counsel has highlighted, I underscore the differences between that case and this. In Howsam, there was no provision in the arbitration clause for a time limit. There was not even a provision in the arbitration clause for who would do the arbitrating and whose rules would apply. It was only thereafter when the claimant, having been given the right in the clause to pick an arbitrator, picked the National Association of Security Dealers, that the rules of that association, which specifically provided for time limits, became pertinent. So therefore, the Supreme Court said the National Association of Security Dealers will be more familiar with its own rules than us, or any judge, and it is for the arbitrator. That is much different than the situation here, where the parties, by consent, in a mutual agreement that should be respected, put in for the 12-month period of time. The issues in Howsam that were remanded to the courts below had to do with issues that are not pertinent to the specific application of our clause. They were whether or not the clause at issue, the contract at issue in Howsam, should be regarded as unconscionable or otherwise revocable. Those are issues that everyone seems to recognize are for the court, and indeed they are for the court, to the extent that unconscionability is even alive in this case. In the court below, finally, we did not argue the merits of the alleged medical malpractice. We pointed out, and Dr. Araya's declaration discussed the circumstances leading up to the agreement, including the provision of this agreement more than a year before the patient signed it, the multiple consultations. We put that in there precisely to avoid any suggestion and to mollify any concern that this was an overbearing, unconscionable agreement. And we put in also into the record the report of the medical examiner of the state of Maryland, which concluded that the patient had died from a pre-existing heart condition that frankly causes sudden death due to heart failure, arrhythmia in young people. And this woman was a college-educated 46-year-old, comparatively young person. We put that in there precisely because of the allegations that were repeated in the briefs below, as if they were material facts supported by any evidence that the death was the result of the liposuction. The medical examiner, the only medical evidence of record, opined that it had nothing to do with the liposuction. But we did not argue for a decision on the merits. We argued that in effect, this agreement should be enforced, which is just another way of saying, in our view, compel the arbitration agreement, enforce the arbitration agreement. And when you enforce the arbitration agreement, per force, you must also enforce the 12-month limitation, which is built right in the express terms of the agreement. For those reasons, and for the reasons that were set out in our brief, including with respect to why the wrongful death claim has been held in this jurisdiction, we're not in Maryland where the minority view was taken, we're in this, that it is a derivative claim deriving from the claim of the decedent herself, and also the fact that in this case, the contract between the decedent, Araya, is being used as the basis for the claim and must be looked at as the claim is resolved, that there is an inexorable interconnection between the two. That works in estoppel. The plaintiff in this case cannot pick and choose what is being applied when she brings her claim. She cannot therefore avoid the arbitration clause, which in closing I say, once there was an agreement by the decedent to have all claims, including the wrongful death claims, the putative wrongful death claims resolved by arbitration, that agreement became attached to any possible arbitration claim that, any possible wrongful death claim that could ensue. It became part of its genetic material. And so if the claim in court is forbidden to the patient, the wrongful death claim is forbidden to the heir. That's what the cases say.
Can I just ask one factual question? Just a yes or no question. I know you're going to tell me you don't think it matters. Is there any evidence about when Alberta Ward knew about this arbitration agreement that her daughter entered into?
The evidence of record is that she requested and received the medical records, the medical chart, shortly after the death of her daughter. And that would put it in about the time she became the person, was appointed by the court as the personal representative. So that would put it in the period of time of 2016. And suit was filed in September of 2018. So the agreement and the consents and all the rest were all part of the chart, which was requested and received at that time period.
Thank you, Mr. Belcour. Thank you for hanging in there with the audio problems. I think we got through it. And thank you, Mr. Hansel. This case will be submitted. next case.
Thank you, Your Honor.
Thank you all.
That's not a good sign. Is connecting, sounds promising, and yet,
Very reassuring.
yeah,
Zoom wouldn't say it if it weren't true.
that's right. There we go. Mr. Schuman, can you hear us? Can you hear us, Mr. Schuman?
Yes,
Okay.
I just got on it. Do you need for me to
No,
make the
I just wanted to
background?
make sure you could hear. I'll call the case now. The final and third case of our regular calendar this morning is number 19 BG 630, In re Jonathan R. Schuman, board docket number 18 BD 20. Whenever you are ready. Have you all decided who is going to go first? Mr. Schuman, I
Yeah, we might
assume-
discuss it, but
Yeah.
I'll go first.
Okay.
All right. May it please the court. First, I want to preface this argument by reaffirming that I acknowledge the severity of what I did. I just do not believe the law was properly applied to my case. Misappropriation, I've kind of briefed to death. I did a motion for partial summary judgment. I don't know whether that's going to be heard. And so I'm focusing on other things. If you want to ask me about that, I will. That's, of course, is good. But first,
I guess I do have one, just to make sure I understand your position about misappropriation. Do you agree that the refund checks at issue were your former client's property?
No.
Do you think you had a legal obligation to reimburse your clients with respect to the funds reflected in the checks?
Yes.
And if you, and just to be clear about the line you're drawing, if you were representing a client and you negotiated a settlement, and the client, the party settling, sent a check to you, payable to you, saying, settlement of proceeds for case X, do you think that check itself would be the property of your client?
It was to settle a case, yes, because it's agreed that the client entrusted the attorney to handle the funds.
And so your position doesn't turn on the fact that who the checks were made out to. You're drawing a distinction between settlement proceeds that are given to a lawyer who is representing a client and refund of expenses that the lawyer has fronted the client and then charged the client for. Is that the distinction? I just want to try to understand the distinction you're drawing.
Yes, I mean, the law says that there has to be an entrustment. The client is giving money is being entrusted to the lawyer. So, for example, if you're billing someone, and if you intentionally bill them incorrectly, and you take money from them, that's not misappropriation. And keep it.
I mean, I think the lines are interesting. So that's a relevant other dot on the map to change metaphors from lines to maps. But if that does seem a little bit different in that what seems to have happened in the settlement proceeds case and in the reimbursement of litigation expense cases, a third party sends a check to the lawyer, and I'm not sure what the third party's thinking is necessarily, or understanding is, about the interactions between the lawyer and the client about it. But basically, the third party is sending money to the lawyer relating to a litigation,
right?
And if the understanding between the parties and the lawyer, the lawyer and the client is such that those funds are something that the lawyer, however they're coming to the lawyer, that the lawyer has a legal duty to give to his or her client, whether directly or whether indirectly. I'm not sure why a line would turn on whether they're settlement proceeds or whether they're reimbursement of expense proceeds.
Because when you get these checks just came in the mail with a case number on them. Because the difference is entrustment.
Well, I'm just not sure why it's not that intuitive to me why the entrustment conclusion is different when a third party sends a check settlement that just says, a case number. And the lawyer knows, those are the settlement proceeds that I have to give my client. At the end of the day, I'm gonna have to give my client those proceeds. If those are treated as entrusted funds.
Because when they get to...
Just to finish the question, because the lawyer understands that this is money that the lawyer has a legal obligation to give to his or her client. If that makes entrustment for settlement funds, I'm not sure why it wouldn't make entrustment if the lawyer understands for a reimbursement of litigation expense check wouldn't also be entrustment. What's the difference between the lawyer's understanding? I've gotten a check from a third party, it's made out to me, but I understand that I ultimately have to give this amount of money in light of what I'm receiving. My client needs to get a bunch of money, a certain amount of money. What is the difference that makes one an entrusting relationship and one not?
Well, the attorney has asked the client has asked the attorney to take the money on behalf of them and has entrusted them to distribute it, to give it to them. That's it's part of the relationship. This is a check that comes in the mail. It's a case number. We have to figure out. When they send the court, when the check sends the court, when the court sends the check, they don't know what. They don't know anything other than that they're just paying back who paid them the money.
You would agree with me, I think, that these $165 writ fees were initially entrusted to you in the sense that they expected you to pay a court fee, right?
I paid the fee first.
I understand. All right. Okay. And then, and does everything turn on that in your mind? If they had paid you and then you paid the court fee and then you got a refund, then that would be entrusted funds?
Yeah, because Rule 1.15E states that like once the bill is paid, once the services are rendered or the cost advance is paid, the money becomes firm money. Is the property of the firm. So when they pay the bill, it becomes property of the firm.
And so remind me, your answer to Judge McLeese's question about whether or not they had any entitlement to these refunds, the answer is yes, but it wasn't entrusted to you. Is that right?
Right. I should have passed on the refund to them. But it's not, there was no entrustment. There was no, acting as a fiduciary. I'm saying HAR in my motion for partial summary judgment. It's when the client asks you to hold money as if it's theirs. I mean, that's not what happened. The client doesn't know if the money's going back.
Well, let's say that you never paid those fees up front, but you told the client you had. And then they gave you the 100, and you said, I need $165 to reimburse me. Would that have been entrusted to you?
I believe them. Can you
Let's say that you said that you paid the $165 writ fees out of pocket,
mhm.
and then you told clients, but you didn't. But you told clients you're going to need that $165, knowing full well that the writ was never going to be issued, and you didn't need one, and then they gave you $165. Was that money not entrusted? Do you think it just falls under some different provision?
I think that might fall under in re Mance, which talks about, it kind of expanded. If someone pays you money for a service, well, if you bill them for something that didn't happen, falsely, that under the law, I mean, those cases are not considered misappropriation. They're all under dishonesty. It's in my.
But are you aware of any cases
Mhm.
addressing a situation where a lawyer is representing a client, and a third party gives money to the lawyer connecting to the representation, that the lawyer legally will have to reimburse his or her client for, that isn't treated as entrusted funds, and if you put it in your operating account, it's commingling, and if you take it out and spend it, it's misappropriation? I mean, your opponent cites a case from New York where, although it wasn't really the issue in the case, the court did seem to treat as entrusted funds, kind of bail bond reimbursements that went to the lawyer. So he's found at least one case that takes that form, although it didn't, again, focus on that issue. But I'm just wondering if you're aware of any setting where a disciplinary authority or a court has said, yeah, it's true that a third party sent this to the lawyer. It's true that the lawyer legally was required in connection with the litigation to reimburse his or her client in that amount, but the lawyer did not, commingle or misappropriate if taking those funds rather than reimbursing, because those are not, in some sense of the word, entrusted. I'm just wondering if you have any support for that idea in this context. I know you have the double billing cases, which is where the lawyer is getting money from his or her client. I can see they're somewhat similar and they're not normally treated as entrusted. So I get that line of argument. But I'm just wondering if you have any that take the form where it's, litigation, representation related reimbursement from a third party that, as I think you've acknowledged, the lawyer has a legal duty to ultimately reimburse the client for.
Well, I think legal duty is a broad term. Like, for example,
well, I thought you were conceding you had a legal duty to reimburse your clients in the amount, your former clients, in the amount of these checks. So I thought it was your term. If it's not your term, tell me how you would describe it.
It's not under the. It's the right. It's correct. It's not. If someone, I should have refunded the money. I don't know. Legal duty is a broad term.
Well, I'm trying to. Should obviously is a broader term because it involves maybe moral responsibilities and the like. And I thought you had said that you believe it was your legal obligation to reimburse your clients in the amount, former clients, in the amount of these checks. Did I misunderstand what you were saying? And you don't think it was your legal duty?
Yes. If they paid me the money, they are legally entitled to it. The refund. I guess that's. But I mean, if you're, that's right. Anytime, suppose you order a deposition, and then the deposition companies, it's $500. Oh, we overcharged you by $100, and you don't refund it to the client, then that's misappropriation and disbarment. I mean,
Well, actually, I'm not sure because that is a different form. That's where the lawyer's original, takes more money from the client in connection with the representation than is, was appropriate under the relevant representation and the events that happened surrounding the representation. And that is a related but somewhat distinct scenario. I'm focused instead on scenarios where a third party sends some money to the lawyer, where I think, again, we're in agreement that you had a legal obligation to reimburse your former clients for the money reflected in those checks. And I'm just trying to figure out whether there's any case support from disciplinary cases or courts or the like for the idea that that's not entrusted funds. And so far, I am inferring that you're not aware of cases that take that form. And leaving that aside, why should that not be treated? What's the reason why we shouldn't treat that as misappropriation? Why is that somehow not as bad as things we do treat as misappropriation?
Because I think it's not as bad. I didn't solicit the money. It was years later. I didn't say to someone, I'm handling this wage garnishment for you. When the money comes in as a wage garnishment, it's the client's money. It never belonged to the attorney. In this case, it was our law firm's money that was being paid back. It wasn't given. It's just a refund of money by my law firm being paid. In any other case you have, when there's a settlement agreement for a doctor's office, the money comes in and it's delineated who it goes to.
Okay,
it's not.
I get your point, and let me just ask one more hypothetical. And I think this touches on questions that Judge Deal was asking earlier.
Mm-hmm.
Imagine that what had happened was you had told your clients, in order to get this eviction done, we need to get a writ of restitution. That costs $165.
Mm-hmm.
I need you to send a check to the Superior Court, with your name on it and this case number to pay that expense. Imagine that's how this had happened, at least in one of these cases. And then imagine you get a check back from Superior Court because the writ of restitution never takes place. And ultimately the Superior Court realizes those issues and sends a check back to you for that amount, to you, to your firm in the name of the firm. Is that entrusted funds? Because the money that it is reimbursing was client money directly provided by the client to the Superior Court. And is that the distinction you're drawing?
Well, those funds were never entrusted.
Well, I'm talking about the funds.
The
trust, for sure, the client never entrusted the funds for the expenses to you. I'm asking whether the check back, if rather than reimbursing your client, you take it for your own purposes, whether the check back is entrusted funds. Because I thought you were making the point that you were suggesting that what happened was the clients paid the firm and then the firm paid the money, and therefore the money that's being reimbursed, if you look at it at the most recent piece of it, is really the firm's money. And I was trying to see whether that is critical to your point by trying to figure out what happens if it's the client's money. The client paid the amount directly. I mean, the original payment was the client's money at all times.
Right.
The client paid the money. Is the check back to the firm entrusted funds in your view?
Can I say I don't know?
Yes.
I mean, I've never thought of that. And I just don't know. Because there's not much on this. There's never been, you say there are no cases in which money being received from a vendor when the attorney advances the fees is misappropriation.
Well, in terms of what the parties, your opponent does cite the New York case. I think there are some more out there that folks haven't cited, but in any event, there is at least the New York case that your opponent cited.
Okay. So, if it's I guess you'll make that determination, obviously. But I don't think it falls within the type of cases. And I think that when you're actually taking money from someone that you know you shouldn't be taking. I mean, I think that's closer to misappropriation than my situation. I mean, you're defrauding some. You're saying,
Although, from your perspective, I know. I mean, misappropriation is to a degree a technical concept, and I thought you were saying that if you're a lawyer and you have an agreement with your client that you'll bill your client, $200 an hour, and you do 1 hour's worth of work, and you send your client a bill for 2 hours worth of work, that is taking money from your client you're not legally entitled to. But your position is not misappropriation. So
under the case law, it's never been misappropriation.
No, understood. I understood. I think you're right that those cases don't seem to be viewed as misappropriation. And so the lines here are hard to follow. But I don't think, I mean, some things that seem like they're outright theft may not be misappropriation, and other things that may or may not be theft seem like maybe they are. So there's a technical concept going on here, and I'm just trying to figure out what it is.
Right. And I think that you have a choice. I mean, if it's unclear, I don't think it's been proven by clear and convincing evidence that it's misappropriation. I mean, you have a choice here. I mean, between, I mean, this automatic disbarment, and I know it's a ton of money, all this. I'm not diminishing anything, but if it isn't clear in the law and there isn't an exact precedent, I mean, if you look at the perspective of, protecting the public and, not the system not being to punish, then I think that there should be a determination that it hasn't been proven by clear and convincing evidence. I mean, I don't think, if you look at my entire record and everything, I don't think that disbarment is, whether it's required by misappropriation, it's required, but I just think it's draconian in my situation. I know I'm not going to minimize the amount of money, but if there's no direct law, I mean, I don't know why I can't fall into something else. I don't know why it's not for sure why I should be disbarred. I mean, I have had, if you go into my, no one had anything bad to say about me. Even first, Tim Cole said that I was not a dishonest person. And I guess we can get the Percy element of it, but it's, that's kind of separate. But in terms of establishing that it's misappropriation, I mean, if the lines are blurred, there's a lot you can suspend me for 3 years, but that's a sufficient. I mean, that's a big, but disbarment, I think, is you should be crystal clear.
I did want to touch on one other topic, which isn't really cursory mitigation. Even I know you haven't gotten into that, and I don't know, take a minute or two to address that. But there is a dispute that's erupted about whether you are or are not complying with the requirements that apply to a suspended lawyer.
Yeah.
Did you want to explain your understanding of what it is you are permitted or not permitted to do with respect to representation, and what it is you've told anybody who you might have any arguable ongoing attorney-client relationship with? It
says if you are in Maryland or in a different state, that the practice of law. First of all, most of what I do is communicate with clients about what's happening in cases. I mean, I'm still admitted in Maryland, and I'm, the other attorney now is has all, well, not now because there's COVID, but at the time, was constantly in court. I'm answering your question. Most of the stuff was stuff that a paralegal would do, but the notes say that, and I think I was going to get to this today, that if you're out of state, you're not in violation if you are making a call from Maryland to DC. it's and I think I had it in the email, or let me find it for you. It's in the notes to the. I cannot practice law in the District of Columbia, but if I'm in an office in Maryland, and I'm allowed to make a call to the District of Columbia. So, and it's not that I'm trying to. I mean, skirt the rules. I'm just trying to help out as much as possible. But I guess I need to find the. B2B. Before the notes. Now, the rule is intended to regulate all practice of law within the boundaries of the District of Columbia. It says here that if you can make a phone call from outside the state and you're not unlawfully practicing law. Find my email.
Mr. Shimon, can I jump to the unless Judge McLeese wants to pursue that further, we can come back to that.
Okay.
Can I jump to the Kersey mitigation issues? If we decided that, just assuming that depression is a disability that, kind of significantly impaired you during the time period, the relevant time period here, what is your best argument for the causation prong of that Kersey framework or analysis?
The testimony of my expert that I
can you tell us specifically?
Yes, that I was impaired. I had limited energy. I was focusing when I was, what I needed to do. And, for me, is that, I was severely, if you look at my records, I have a severe underlying mental health issue. And, I'm asking you that all the evidence be looked at. And they didn't mention my Johns Hopkins. I went to Johns Hopkins for myself. I was so depressed. It's not anywhere in the report. In November of 2012, when you refer yourself to Hopkins, you're not just down, you're desperate. And it's not anywhere. No one reported it. And I went and got help, and I was adjusting medications. And I've showed that in college, I dropped out of college because I was so depressed. And it said that my medicine had no longer, at the end of 2012, it stopped being effective. And it was affecting my ability to function. Those were the words. And I have that quoted in my brief. This is a severe problem. This is not me. I went along with the situation. I could only handle so much. I was the firm was having issues. I had no energy or very low energy, low motivation. I focused on what I did. I acquiesced to my staff. This was, so I did not say, oh, I'm going to take people's money. I rationalized it. I was in denial, but
it sounds like you're describing negligence.
I think that, if it's misappropriation, I'd love it to be negligent. Because it applies. I just don't. I knew what I was doing. I didn't think it was wrong, but I don't know where the interplay. How can a Kersey defense usually it's a defense to the determination of what happened. Can a courtesy defense turn, affect whether there's negligence or intent or recklessness? It's usually there's a determination of this, and then the courtesy is the mitigation.
Can I ask you about your wording? You said a minute ago that you acquiesced to your staff. Was there testimony that this idea originated with a staff member?
Yes.
That was
That's Teresa Hampel. I put it in my
I know there was evidence you consulted with your staff and the like. I just was unsure that.
Right. Well, they strongly suggested it. I was dependent. I mean, I tried to downplay this because I didn't want to look like I'm putting on other people, but I was dependent on that. I don't think it would have been credible, but at that point, my self-esteem was so low, I was relying on them, and they wanted to keep it, and I agreed, and I'm responsible for it. It's my firm. I mean, I don't.
Okay, thank you. That's very helpful. I'll check that testimony. Thank you. Can I ask you a framework question about this issue that Judge Beckwith raised about kind of the causal connection between your situation and the conduct at issue?
Yes.
Do you agree that this court should defer to the hearing committee's conclusions about that, because it's really essentially factual in character, and that's for the hearing committee to decide in the first instance, and really for the board and this court to defer to unless it's unsupported by the evidence? Or do you think that's something that this court, to focus on the current decision maker, that this court can and should be sort of deciding de novo and figure ourselves out whether we think there was the requisite causal connection?
Well, they used the wrong law. So I think you need to look at the law.
Okay, but leave aside, that's a fair response. So I take that point as far as it goes. But assume for a minute they hadn't applied the wrong law, and it was just, they look at the record and they decide, there's conflicting testimony on this. There is evidence indicating that at some of the relevant times your condition improved a lot, and there's the contrary expert who I know you have concerns about in various ways. But in an ordinary case where let's assume they weren't applying the wrong law, is that something that ordinarily we would be deferring to the hearing committee about?
If it's not a legal question, if it's a legal question, it's de novo. If it's not, it's clear error, I believe.
And that's what I'm asking. In other words, what I'm asking you is, assuming that the hearing committee has said the law correctly. So let's say it says it needs to be, substantially affect, if you think that's the right law.
Right.
That's the right way of describing the causal nexus. When the hearing committee says that and says, we've heard conflicting testimony, we decide that there wasn't a substantial effect because we are more persuaded by this set of, pieces of evidence than other pieces of evidence. Is that something that we would ordinarily review deferentially?
Sure. But in this case, they came up with new requirements that I wasn't given notice of. I mean, this whole disabled, he said I was disabled by depression, which is not, it's the three elements. You have a disability, it substantially affects your conduct, and you're rehabilitated, and that's not the issue. And that's not disputed here. So they kept saying, I'm disabled by depression. So what does that mean? They asked Dr. Candilis what that means. And he said, I don't have a definition. So first of all, I was not put on notice in advance. I only knew the three elements that are in every single case. And in the Washington Law Journal's article by the disciplinary council, the three elements that you follow. Everyone follows these three elements. They're switching things up. So, and they like that better, but I didn't know. How can I prepare for a standard that I don't know about? I mean, that's really not fair. And especially and even if I was talking about disabled by depression, they don't have a definition for it. So how can I, even if I knew that standard, I don't have I don't know it doesn't have a definition, so I have no way to prepare for. And the same thing, the other thing they did, which is not a real fabrication, is that, and the court adopted this. They said, respondent has not identified any area in his life in which depression disabled his conduct except for the purposes of defending this action. Now, I don't think that's accurate, but that's saying that I had to show that the depression affected not just my work or this great situation, but other things in my life. That I could have done. But if that's the new requirement, if that's the new law, I deserve to have notice of that.
Sure. I don't think it was a requirement, but I think it could have been evidence in your favor that wasn't presented. I think all they were saying is, if this were so pervasive, like, this doesn't look like mere debilitation because it looks quite deliberate to refund current clients' money, but not former clients. It doesn't have the feel of somebody who's just debilitated. It has the feel of somebody who's thought it through and come up with a scheme. And then when they say, and it wasn't affecting other parts of your life, it's not that that was a requirement that you had to show, but that could have helped you, and you didn't provide any evidence of it. I think that's what they were saying.
But you're supposed to show a nexus between, that's the element between the wrongdoing and the mental health issues, and which I did. And, it says I did not identify. I was not required to identify any others, and there are other things. And also, I explained in throughout the hearing that I wanted to keep my personal life personal and not put things about everything I said in that hearing could go on the internet. But you have in there that evidence that I was in an abusive marriage, that I had trouble dealing with my wife. I mean, that definitely had my mitigation, my mental health, it definitely had an effect on that. That Dan Morgenthaler would say, if she screamed me the office, I lived in fear. Would I handle that differently? I mean, how would I show that it show that, and what's an area of life? I mean, how would I show that, excuse me, that this was the depression affected another part? I mean, how do you find similar, context? Should I have shown I neglected my child? I mean, and also the level. If you look at the other cases, I mean, they're not citing these other cases. Katz and Capel and Vera, people, purposely wrote checks they weren't supposed to write out of escrow. There are all sorts of deliberate things people did. And mine was passive. I was focusing on other things. I didn't, they were doing this. So you say it's deliberate, but if you look at, and that's the only thing that bothers me, is that none of the mental health disability cases were brought in. And the people knew what they were doing wrong. And they, did things that were much more blatant and active. I mean, like, signing checks, forging checks. So, and mine was passive. So I know you said that, oh, well, it looks deliberate, but there's a lot of people did deliberate things, knew what they were doing, and still were given the Kersey defense. We're still given a full Kersey mitigation. And that's what I was using. And, they didn't even address those cases. They didn't address my Hopkins report, which I think is so important because it shows, they didn't mention it. And it was a month and a half before I went in there saying, we'll find the quote. There's lots of stuff saying my medication had run out and it was affecting my ability to function. None of these have perfect, connections. It's just, none of these cases have ideal or, every moment is accounted for and I mean, a lot of these people were like writing checks out of their escrow account over and over and over again over time after being told not to, and all this is, well, this expert we gave, felt stronger about it or something. But for me, I'm not even being, provided the benefits, the protections that were provided other litigants. If all those people, Katz, Capel, Vera, were given mitigation, I should be given mitigation. It's not. I mean, this really is. I look at the law and I base it on the law, and that there's not, and on the prior cases, and they took this case, I'm sorry, it started with an R. We're talking about disabling the person who had, a drug addiction, and they use the word disabling, and they're combining elements 1 and 2. I have a disability. So the question is, does disability affect the conduct? And yes, it is. And also, I mean, I know this is not part of the record, but it's just not me. It's not me. There's nothing in my history. They could have brought in other attorneys. They could have brought in, my opposing counsel, legal aid. They could have all these people to say what type of person I am. It's just not me. I did not intend to do anything wrong, and it sounds stupid. In hindsight, it sounds ridiculous, but that's where I was at that point. I was not saying, "Oh, let's steal money." So, if I just think that this is. I lost my train of thought, but and you just look at the other cases. So the bar is not that high, and that's why these people were given mitigation. And why didn't they even, the board or the hearing committee, even mention the cases about a mental health mitigation? And Capella had the same symptoms as me. Even they all were living their lives. They all were practicing law. They weren't debilitated. So, I just want to be my case to be considered like everyone else has, and it hasn't been. They came up with their new standards. They didn't use. I'm the only person who testified regarding the actual Kersey elements. They came up with these nonsensical. I mean, if I went in court before in Superior Court and I hired an expert and I spent thousands of dollars on the expert and for my client's money, and I went and I said, "Oh, well, this is my," and the expert says, "I based my case on disabled by depression," and the expert says, "Oh, I don't know, I don't have one," I'd be in big trouble. But here it's a winning argument. I mean, I'm just used to Superior Court. I followed the rules. I took, I applied the law. I took the evidence and applied the law. I, made intelligent legal arguments. Here, things just being made up as they go along. And
Mr. Schuman, sorry for interrupting, but and we've given you a lot of time, so we're going to wrap it up. But I do have one quick question for you, which is your argument that that basically disabling as a factual finding, or that disabling isn't part of the test, or is your argument that you were disabled? You seem to kind of switch back.
No, I'm saying it's not part of this word disabling is not part of the test. The test is you have a disability, and did the disability affect the the behavior,
so
the conduct? So it's not disabling combines the 1 and 2. It's saying that you're disabled, and it's something that's so severe that would I don't know, cause that it would be a factor or a substantial factor in the misconduct.
Because I thought at some points you seem to be saying, as a factual matter, you also were disabled, or that's a backup argument.
No, I said I have a disability.
Okay.
And I mean, I have a disability, and the disability is substantially affected. I mean, that's what I use. That's the standard. And here they're new standards, and I should have known about those before the hearing. And the disabling isn't even defined anywhere. I mean, it's just.
Okay. All right. If my colleagues don't have any further questions, we will hear from Mr. Lowry, but I will give you a few more minutes on rebuttal, Mr. Schuman. Thank you.
May it please the court, Jelani Lowry for the Office of Disciplinary Counsel. Disciplinary Counsel agrees with the board's findings of fact, conclusions of law, and recommendation of the sanction of disbarment. This case is pretty straightforward in terms of the facts. Mr. Schuman does not dispute most of those facts. Those facts are that from January 2013 through March 2014, he received over $300,000 of writ refunds from the court. He deposited those funds into his operating account, thereby commingling them with his own law firm's funds. He violated Rule 1.15C when he didn't inform his former clients that he had received refunds in their cases. And he misappropriated when he used those funds without authorization from his former clients to financially support his firm that was going through a struggling financially at that time. Disciplinary Counsel submits that the facts as found by the board are supported by substantial evidence in the record and should not be disturbed by the court. And that the writ refunds were in fact property that falls under Rule 1.15, entrusted funds as defined by Rule 1.15A. Rule 1.15A defines trust funds, which I submit are the same as entrusted funds, as funds of clients or third persons that are in the lawyer's possession in connection with a representation. So any funds that an attorney receives that do not belong to the attorney, that belong instead to a client or a third party, and that come into the attorney's possession as a part of a representation, are entrusted funds that.
So do you agree or disagree with your opponent that double billing cases are not misappropriation cases? So again, in the hypothetical where I am representing you and we have an agreement that I'll charge you $200 an hour, I actually work an hour, I falsely and intentionally say I work 2 hours and I get $400 from you. Is the extra $200 when I take it, assuming I then put it into an operating account and spend it, is that commingling and misappropriation?
We don't have cases where we've charged that and the court has found that. But at this point, it does seem that if an attorney asks for additional funds, for example, in an advance fee, it depends if it's an advance fee or a billing.
Well, the hypothetical I gave is very clear to what it is. It's not an advance fee. It's
right.
For work that's been done, allegedly, but actually hasn't half of it.
Right. I think disciplinary counsel might argue in a case like that that the attorney was accepting, if it was an ongoing case where the client was being billed monthly and that the attorney.
You keep wanting to complicate my hypothetical. I just keep it as simple as we can. Imagine that's the only thing that happens. Is that misappropriation, commingling and misappropriation?
I don't think I can concede at this point that it's not misappropriation.
Well, I'm less interested. I mean, that's helpful, but if you're not sure whether that's commingling and misappropriation, then it seems to me you're not sure about the accuracy of what you said at the beginning, which is it's always taking of entrusted funds. If you get property, if the lawyer in connection with representation gets property that belongs to the client. So it seems like if you're not sure about the answer to that question, then you need to explain why, what your theory is about what makes something misappropriation that definitely applies here, but may or may not apply to the hypothetical about double billing.
Sure, and I think that's the reason why I keep trying to add facts to your hypothetical, is in order to explain. And the way that I would like to explain is that if an attorney was to receive a double payment for, let's say, the January bill, and I think that it is a factual determination that has to be made. The attorney needs to know whether he has double billed and received additional money. Once the attorney knows that, it's the attorney obligation, I think, to either refund the money or to notify the client, hey, I have the money. Do you want me to keep it and apply it?
Yeah, certainly, it certainly is that obligation, but I'm trying to figure out whether it is entrusted funds and commingling and misappropriation if the lawyer doesn't do those things.
So I would say yes. If the attorney realizes that the money belongs to the client and that it's been overbilled, and the attorney keeps that money in his possession and does not inform the client that he's double billed, does not take steps to either ask for the client's permission to put that money into a trust account and hold it for future services that will be provided, or like I said, refund the money immediately, then you also have to prove that the balance in the attorney's account, wherever he put the money, falls below that. I'm sorry, Mr. Judge McLeese, you're muted. Sorry.
For misappropriation, yes, usually no. Right.
I'm sorry.
For misappropriation, yes, but for commingling, no.
Yes.
You wouldn't have to actually spend it. So if I am a lawyer and I don't do a good job of keeping records, and let's say I not just negligently but recklessly but unintentionally overbill somebody. So, I think I did 3 hours worth of work. I really, and that's what I tried to bill for, but because I recklessly do my record keeping, I bill for 4 hours. Your view is that's reckless misappropriation, assuming I then later spent, put the extra money in my operating account and ultimately spend it. And I should be disbarred, barring Kersey mitigation, for reckless overbilling.
I do think that if there's a continued pattern of recklessly taking funds from a client and using those funds for your own benefit without authority, I do think that and I'm sorry, you said disbarred for recklessness, and I do think that would be again a factual consideration that would come down to how many times has this happened. And you said recklessly, so I think we're talking about a situation where it's happened a large number of times. Then that would be something that should be considered entrusted funds.
What about Dennis Clark, which does seem like intentional overbilling case where bar counsel conceded that there was not sufficient evidence for a misappropriation finding, and sure looks like a lot like the hypothetical that we're talking about here. And I guess I wonder if you have a distinction of Clark, or is there some other explanation of why bar counsel isn't bringing these as misappropriation cases? Like there's a more direct route to getting at that kind of conduct?
Sure. I do think there's a more direct route, which is the dishonesty, but I'm not saying that disciplining counsel would never charge that in that situation. For Dennis Clark was a negotiated disposition, and negotiated dispositions I think are not a precedent that we cite to. But in addition, disciplining counsel agreed in that case that we did not have sufficient evidence to prove misappropriation. I don't know the specific facts of that case or why we didn't have that evidence, but I would say again that we always have to prove that the money was spent and that the balance in the account fell below what the attorney was supposed to be holding. And when we did, if it's possible, I can't say for sure, but it's possible that we did not have that evidence in that case.
Can I ask you, I hear an echo when I'm talking, I'm not sure why, I apologize for that. I hear, do you think, again, leave aside the technicalities of it, but just from the point of view of what is worse and more deserving of sanction, more of a concern, do you think what Mr. Schuman did is worse than if a lawyer had intentionally overbilled his clients by the same amount of money?
I'm sorry, I'm trying to mute and unmute so that there won't be an echo. I do believe that they are the same. Taking money from the court as it comes in and overbilling the client. If for example, if Mr. Schuman had sent, bills to these clients over that course of 14 months, asking for money that he hadn't earned, the sanction, I think, should still be the same, even if the court were to decide that it should fall under 8.4C as dishonest or fraudulent conduct, or maybe as theft. In any of those scenarios, the sanction should be the same. The conduct is taking money dishonestly that doesn't belong to the attorney, repeatedly over a long period of time in large amounts. So going just to close the loop on the entrusted funds idea, one of the things that the respondent has alleged is that there has to be some sort of actual entrusting, some verb-like action by the person giving the funds, and disciplinary counsel believes that that's not necessary, that it is indeed the character of the funds themselves that make them trust funds. Moving on to whether it was intentional, reckless, or negligent, the evidence in this case only supports the conclusion that the misappropriation was intentional. Respondent early on knew that the money belonged to his clients. He had conversations with his staff. His staff contacted the court to find out what the money was for. They found out that it was refunds of those marshal's fees. And then Mr. Schuman made the decision to keep the money that belonged to his former clients, but return money to his current clients. And that demonstrated his knowledge that these checks actually belonged to his clients. He sent them to his current clients without any notation or other sort of disclaimer saying, these don't belong to you, but I'm giving them to you anyway. He instead sent them under a 1 or 2 line letter that said, these are the refunds that came back from the checks that in the cases that we have for you. So that evidence showed that he was acting intentionally. Again, you also have the circumstantial evidence that involved Mr. Schuman's firm's struggles, his concern at the time, and his intimate involvement with the firm's financial state, his concern that he didn't want to lay anybody off or reduce any salaries, including his own salary, which turned out to be about $300,000 during that same time period.
Counsel, if I can move you on to the Kersey mitigation. Again, apologies for the echo. I'm not sure why that's happening today. I have a question about the first component of the Kersey test, because in some of our cases, we refer to that as requiring the respondent to show a disability. And sometimes we use the word, in some of our cases, we use the word impairment. Is it your sense that there's a difference between those, and that there has to be, if there's an impairment, that's not enough? It has to have certain fundamental or really severe characteristics, maybe rising to the idea of disability as it's defined in, federal and local discrimination type statutes. And if that's your view, why do you think that is? What support do you have for that view? Why do you think that should be the approach?
My view is that that disability and impairment are essentially the same. That the respondent has to show that he is functionally impaired at the time of the misconduct, and whether that be, I'm not sure whether.
So then, how could the are you disputing that he had an impairment at the time of the conduct at issue? I mean, he had a diagnosis of a mental health condition that does, impair life in a variety of respects. That's why it's treated as a mental health condition that calls out for treatment. So if that's all that's required, is that you need to have something that, you have to have a condition that impairs you, why are you disputing, if you are, that he had that?
Well, I'm disputing that the condition actually impaired him at that time. And the reason we are disputing that is
I
because
mean, at all. You think he was suffering you think the evidence supports the view that he was suffering no adverse symptoms from his depression at the relevant time? Zero.
we think the depression was managed to the point, and I would come back to, I would skip ahead to rehabilitation in order to explain this, but we think that the disability or the disorder was managed to the point where respondent, Mr. Schuman, could have brought this evidence, if I can make the hypothetical and push the time period, change the time period of the misconduct to November of 2012, when Mr. Schuman is claiming that he actually did go check himself in to Johns Hopkins, I think it was. And if we were dealing with a situation where the misappropriation happened during that month, and then we were at a hearing during the next year in 2013, and Mr. Schuman came forward and said, here are my notes from Dr. Hodis, my treating psychiatrist, and here they are, and they show that I am on these medications and that I have been attending these sessions with her monthly, and that I have Dr. Hodis reports that I have reported to Dr. Hodis that I am 8 out of 10, and Dr. Hodis agrees on various occasions. That would be the type of evidence that we would look at to see, is the impairment gone? Is he ready to go back and practice law again safely? Are we ready to send him back out safely? And what I'm saying, and the reason I think that's relevant here, is that he met all those requirements during the time that he was actually misappropriating. And I think that if the impairment has been cured in a disorder or disability that is something like alcoholism or depression, where you can be in remission, which is what we have here, the first prong of Kersey cannot be satisfied. And another reason is that another reason to distinguish those things, and I would go back to Stanback, where the court held that this clear and convincing evidence standard is appropriate, and that these two prongs are really very separate analysis that have to happen. If a respondent is not suffering from that type of impairment, if a respondent is in remission, there is no way to prove causation. There is no need to reach that second prong.
Right, and that, well, I mean, you said two things that are slightly different. I think I understand your line of thinking to a degree, but one could take a different view and say, let's take the example of someone who is an alcoholic, has been diagnosed and had serious problems, and then is got that condition, under control, so that the person is now able to function well. One way of looking at that is the person has no impairment, or for purposes of disability law, they might actually still have a disability law as that's defined in federal disability law. I'm not sure. But another way of looking at it is they have the impairment, and if they're going to not be able to prevail under Kersey, it's not because they don't have an impairment or a disability. It's because they're not going to be able to show a causal nexus, because it's not actually causing them the problems, and in particular, it wouldn't be sufficiently have a sufficient causal nexus, causal nexus to the conduct at issue. So it seems to me like some of the points you're making about whether the condition is creating real problems could be perfectly well handled at the second part of the Kersey analysis.
I think you're exactly right, and I think that in this case and in other cases, the result is not going to be different whether you look at these facts under prong 1 or prong 2 of Kersey. You have to look at them under one of those prongs, and when you do, the answer is that respondent has not met his burden under Kersey. And so in fact, that's what happened. The hearing committee looked at these facts under prong 2, and the board agreed with us that they fell better under prong 1, looked at them there. But I will say that we still haven't had any discussion really of connecting those two things, which is the impairment to the misconduct itself. And there are different types of misconduct that are charged in different cases. And sometimes the misconduct, the Kersey mitigation only applies to some of the rule violations, not all of them. And that's illustrated in the Lopes case, where the respondents there, Mr. Lopes, I think this case, did not prove the causal connection between the dishonesty and the fraudulent conduct. That's cited by the board in its report. So the respondent in Lopes got Kersey mitigation with respect to the other rule violations, but not the dishonest rule violations. And again, here, respondent engaged in a course of conduct that was dishonest for over a year, and respondent had the burden to show that his depression caused that misconduct. And getting past the extent of his impairment, even once he shows some impairment, he has to connect that to not only the fact that he misappropriated the funds, but to the fact that he had this dishonest scheme and made these decisions. And our expert testified that he did not have any kind of impairment that was connected to his ability to make these decisions and conform his conduct to the rules. To his decision-making capacity with regard to these refunds was not compromised in any way. And Mr. Schuman's expert did not testify, could not even testify to a reasonable degree of certainty that his misconduct was caused by the depression. I think the hearing committee said that she acknowledged that she could only speculate as to whether his depression disabled his judgment, and using the hearing committee's words, lamely concluded that despite respondents' partial remission from major depressive disorder, there may have been some remnants of that depression that affected him at the time. That's simply not enough. Respondent has said here before this court that in other Kersey mitigation cases, the bar is not high, and that the burden, suggesting that the burden should be an easy thing to meet. And we're talking about, that's simply not true. We're talking about an extraordinary remedy that drastically reduces the sanction of disbarment, which this court has, the presumptive sanction of disbarment for misappropriation, which this court has put in place to safeguard the public against attorneys who are misusing client and third-party funds. And so it's not an easy burden to meet, and it should be a high standard. And respondent did not meet that burden in this case.
I think his argument was there are cases where it doesn't seem like it's a high bar.
My response is, again, if it didn't seem like it was a high bar, it was a high bar, and the court has held that this is a clear and convincing evidence standard under Standback. The court has maintained that since Standback, and the court does not simply hand out mitigation for Kersey. It's a burden that's placed on the respondents, and they have to produce sufficient evidence to show that that they were suffering from an impairment, that it caused their misconduct, and that they're rehabilitated, so that this court can know that they are that it was the fault of the disorder or disability and not the respondents. And in this case, it was the respondent who was taking these actions, and it was not the fault of his disability.
Okay. Thank you, Mr. Lowry. Did you have anything else you wanted to add? I didn't mean to interrupt you.
Sure, just two more small things. One more small thing. The court has addressed the notice of noncompliance with Rule 14, section DC Bar Rule 11, section 14. And I would just say that we have not had a proceeding alleging that respondent engaged in unauthorized practice of law or taking any sort of other action where he would have the opportunity to respond and develop a factual record. So we're not asking that he be found to have engaged in that. We're simply asking that he be required to comply with that before his period of suspension. If this court disbars him or suspends him, that any period of suspension or disbarment begin to run after he, for reinstatement purposes, begin to run after he complies with that rule. and require him to actually comply with that rule and provide notice to any clients in DC matters or adverse parties in DC matters that he is actually suspended. If there are no further questions, disciplinary council asks that the court adopt the board's findings that respondent violated rules 1.15A, 1.15C, 8.4C, in order that Mr. Shuman be disbarred because he hasn't met his burden under Kersey.
Okay, thank you very much, Mr. Lowry. Mr. Shuman, we'll give you 3 minutes.
Okay, I'll make it quick. First thing that DC Bar Rule 15.182 defines disability as a mental or physical infirmity or illness. So it's a broad definition. We have a definition on hand that I cited, and no one's has been willing to. The board, the hearing committee didn't acknowledge it's right there. The bar has its own rules of what a disability is, or own definition. Secondly, there are a couple of things there. It's mentioned twice that I bought a house during this time. That is not. That it's misleading, or you can get the wrong idea. If you look at on the I think it's August 3rd entry, 2013 with Dr. Hodis, it says bought a ranch for my wife's. My wife has a heart condition, so it's not like I mean it looks like I just got money. I went and bought a house. It's misleading. It was for that purpose, and also there's no evidence that it was involved in any way with getting the house other than showing up for closing and signing a contract. I mean, Candela said, oh, Mr. Shuman bought the house to accommodate his wife. There's no evidence that that's the way it happened. And they're using that, and in terms of paying myself extra money, I didn't pay myself more than my usual salary. That I explained at the hearing. And, the hearing committee said, it's hard to feel sorry for him because of that, or me because of that. I'm just talking fast. I'm trying to get it out. But I testified that, it was my wife, bullied me she was working at the firm at the time, taking the money out, that, I was in an abusive marriage. I didn't have a choice. And even my associate, or now my partner, who I didn't ask to testify, said how she would, at the office, she would be screaming at me. So that was not something that there's more to the story. I just, it looks bad, and I think it makes, but anyway. And then the other thing is in terms of the notice that he filed, the rules of procedure permit me to file exceptions with the board. And I don't know if you want me to file a copy of my exceptions with the board with you.
Judge Beckwith, you're on mute.
Hello?
Sorry, I said I thought we had a copy.
I have I'm entitled to file exceptions to it under the rules of civil procedure, and the board makes a recommendation, which I don't know what it's going to be.
Oh,
but
you're saying that you have filed, that you have.
I have not filed it. It's not due till tomorrow. I wanted to focus on. Would you like a copy of would you like me to file a copy of my exceptions, or?
If I feel like they're gonna come to us
Okay.
somehow. I'm not sure. Or if you could file a motion asking us to supplement the record if it's not already part of the record somehow.
They can set it for a hearing, all this stuff. Anyway, and I believe that's. And can I say one more thing about the record keeping, and about the discrepancy between the amount of funds that were not paid and the discrepancy between the money I was able to find records for and the money that and there was money that I was not able to account for. I was just told to explain the difference. I mean, for each check that came in, Allied has a check number. For each one, I would have to go back and figure out. I look at the case, figure out who the client is, figure out what the billing code is. None of these were my records. And so I spent a ton of time and I got $27,000 and I thought that was enough to, I'd take the client into the archives and I had to find when it was billed and I had to find out when it was paid or if it was paid. I mean, it was a huge, huge task. And I thought $27,000 of it would be enough to satisfy them. They said that was to provide an explanation and they didn't complain about it. And then now it's that I didn't, keep records, which there's no evidence that it was my records or anything like that. I mean, this is the board. The hearing committee said I didn't, violate the records, and I need to, give the money back to the other people, and I have no guarantee I can find out who those people are. These are old records. They're not my records. They're just people who paid bills. I don't even know. They're all archived. I don't even know, So anyway, I just wanted to put that in there that I don't think that's the evidence supports that.
Okay. Thank you very much, Mr. Schuman and Mr. Lowry. We will take this case under advisement and
Okay.
the court is now adjourned.
Okay, this court is now adjourned.
Thank you.
Thank you.